fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your gracious host, Daniel. And today is Judge Aaron Gauthier's court docket. Again, I would like to thank all the subscribers to the channel. Thank you very, very much for your support. It means a lot to me. And if you feel more comfortable on Rumble, the links to my Rumble page are on the main page of the channel. So let's get started with Judge Aaron Gauthier. I don't know how to pronounce his name. And make it bigger. And as usual, I'll be watching, but I'll have my mic muted. So let's get started.
Telling you, I'm gonna refer this back to Judge Bisonow so you can appear in person with him for an arraignment. Do we have a date?
Okay.
I'll give you a date. June 8, 8:45 a.m.
Okay.
No calling in, no car broke down.
Yep. Okay.
You're gonna be there, okay?
Yes, sir.
Okay.
Thank you.
All right, and we are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we handled something on our youthful offender docket off the public record. And now we're beginning our adult criminal docket in People v. Cater, file 26-7157FH. Counsel, you want to state your appearances, please?
Counsel Goodrich, Wayne County Prosecutor.
Ryan McLean, on behalf of Josh Cater. He's a counsel to the residents. For purposes of status conference, I can give the court an update on where we are.
Okay, very good.
I did talk with Ms. Goodrich today. She texted me while I was in court in Charlotte and made a best and final, which is just for the court's record, is drunk driving, third is a habitual offender, second, dismiss the habitual offender, 4, and there's a misdemeanor count 2 that's also being dismissed. I needed to come over here, spend some time in Ms. Goodrich's office. I had to go over Mr. Cater's prior records to make sure his prior record labels were scored properly. I have that information now, both that was misdemeanor and felony side. So I think the court can safely set this for a plea, and what I suggest to the court, I'm back in front of you on People versus Hush in early July. So I know you have a docket day then. I don't know if you have a docket day before that, but I'm here anyways on Hush. And I was suggesting to just set up for a plea on that day if it works with the court schedule.
Any objection to that, Ms. Goodrich?
No objection.
Okay, so what we'll do is we'll we'll continue the docket call to July 7 at 1:30 in the afternoon. And we'll have that serve as a plea cutoff date, and we'll give a firm trial date if it's not resolved then.
Okay.
And we also have a show cause up. Mr. Cater, it's alleged you're in contempt for a bond violation for submitting a dilute urine sample for testing on April 8th. You have the right to have a hearing on those allegations where they need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer to present evidence in your own defense, to question the evidence presented against you. If you are found to be in contempt, I could jail you up to 93 days, fine you up to $7,500 or both. I can also revoke your bond if I believe you're not complying with your bond. I do note, Mr. Clayton, we have had a good and valid negative test since that time. So unless Ms. Goodrich objects, it'd be my intention just to continue bond and set it for continuing status. Do you know how Mr. Cater wishes to proceed on that?
That'd be fine with this, Your Honor. And just the court knows, there was a medication change right around that time. But I also note that I've not received anything since that date. So I think we have it all sorted.
All right, so I'm going to enter a plea of not guilty to the contempt. We will set it for a status conference on the violation on July 7, excuse me, July 7 at 1:30, the same time as the docket call. I know we had a little bit of some issues with Mr. Cater asserting some problems with that, and I declined to amend his bond, and it seems that he's been able to bring himself into compliance. As long as you stay in compliance, we're going to be okay with this, okay? Okay.
And Your Honor, I appreciate that. Just so the court's aware, I don't know why it was such an issue. I did talk to the testing facility, and they just were able to figure out a way to have him take his urine test sitting down rather than standing up. It's worked out fine.
Okay, okay, very good. All right, we'll see you then.
Thank you.
Oh, can counsel approach?
Yeah.
This is in both files, we call it a docket call hearing. I know other counties sometimes refer to it as to like a jury status conference or something, just to see, are there any motions that you anticipate filing? Is the case resolved? Does it, do you want more time to see if it can be resolved, or are you ready for it to be placed on our trial docket? So what can you report to me in that regard on both these files, Ms. Guzman?
Yes, Your Honor, again, I had a meeting today with the prosecutor in person at her office. We discussed this case again in detail, and we discussed what seems to be a potential resolution in this matter. However, it is pending for the prosecutor to speak with the prosecutor in Presque Isle County. So we agreed that we were going to be asking for an adjournment of today so that we can explore the possibility of a potential resolution in this matter prior to moving forward.
Are there any charges in Presque County?
There is, and currently we have a combo offer. So if there's any modifications to that offer, I have to reach out to the prosecutor.
And Your Honor, in Presque Isle, my Attorney Gilbert from the public defender is the one handling that case. I'm not the one. However, we have been in communication, and we are, as prosecutor mentioned, trying to find a global resolution to the cases.
Okay, and I'm the judge in Presque County as well. It's the same circuit, but I don't recall maybe it hasn't been bound over yet or something. I don't
It
know.
hasn't been over. My
Okay.
understanding is that today was the preliminary examination
Okay.
and it was pushed out
Okay.
pending resolution of this matter.
Okay, very good. We also have, even though Mr. Watson is in the jail, the law enforcement did file a complaint for violation of his conditional release orders for no contact with the victim or family, and attached some letters to that. So we do, even when they haven't posted bond, we do enforce those no contact orders. As I understand, the law does allow those portions to be enforced. So Mr. Watson, you could be held in contempt for that and jailed up to 93 days or fined up to $7,500 or both. Also, you know, I know that, is this a bond that just hasn't been posted, or is this a bond canceled case? Was it bond was canceled in district court maybe? Oh yeah, it looks like bond was canceled in district court.
Your Honor, his bond, he was serving for probation violation on a separate matter. And then we were notified as well of this letter of a no contact, and that he pled to the bond back from the probation violation, and he's serving time because of that, or I think he already has finished that time. And then we do have pending that bond violation, which is part of the negotiations that we discussed this morning with the prosecutor.
Okay. All right. So what I'll do is enter a plea of not guilty on Mr. Watson as to any contempt for that violation.
Yeah.
And I'll just set it for a continuing status conference on that pending bond violation at the same time as the docket call. And just advise you, Mr. Watson, even though you're in the jail right now, you might think, well, what more can I do to you? If I cancel your bond, you're already in the jail. But I assure you, unless this case ends with you receiving not guilty verdicts after a jury trial in 2 files, I'm going to have to sentence you at some point. And how you behave in the jail does in fact matter. Sometimes people think it doesn't. When they're back there, they just think like the world is not going on and it's just what's back there. What you do back there does in fact matter. So I want you to follow those restrictions. You don't have any contact with the victim or their family. And I don't want to be being told that, you know, you're causing problems for any corrections officers or anybody back there, because if I get to a point of having decided on your sentence, your lawyer will tell you those things are going to be something I take into account. Okay. All right. Anything further from the defense?
Your Honor, the one thing is, for the next 4 days, is that something that we can discuss for a date?
Oh yeah, I'm sorry. Yeah, I'm supposed to give you a date.
I just want to make sure that I'm available to go down.
Yeah, Ms. Goodrich, I've got dockets the next couple of weeks and then not again until July 7. You want me to give it to July 7 for you, or
That may be helpful.
July 7? Okay.
July 7 works perfect for myself.
And Ms. Guzman, does morning or afternoon work better for you? And I would allow you to appear by video if you wish. And if you want to zoom in, just let us know and we'll make sure that we have the jail zoom your client in from a
Thank you, Your
room
Honor.
or two.
If we can schedule it for video, but if I have to come like today, that was scheduled for video, but I needed to do some things in person, then we can come.
Yeah, you're always welcome in person.
Thank you, Your Honor. I appreciate that.
Okay.
I prefer in the afternoon,
Okay.
because I'm really far from here, but
Okay. Well, let's schedule it for July 7 at 2:30 in the afternoon.
thank you, Your Honor.
That's- Anything further from the defense? Anything further from the people?
No, thank you.
Anything further from the defense, Ms. Guzman?
No, Your Honor. Thank you.
Okay, have a good day.
You too.
A lot of the reason for seeking treatment in the first place. Nonetheless, that is, at least from my understanding, the reason that we do not have that letter today for the court.
Yeah, we've run into that problem in our treatment court with some frequency, and it's a bit frustrating.
Right. And so I did want to let the court know that we did actively try to get Mr. Chapman to treatment. Unfortunately, we were not successful. I think his plan, as soon as his feet hit the street, is to continue down that road of seeking actively treatment, whether it's inpatient, whether it's outpatient, whether it's intensive outpatient. He's very willing and knows that it's necessary at this point that he gets a hold of this problem for himself and for his family. This is, I don't think anything that Mr. Chap ever thought that he would be sitting here facing these consequences for. Certainly not for, almost getting in a fist fight with his grandfather on the side of the road. That is a terrible look, and he understands that. I think that he's committed to making sure that this never happens again. And part of that is seeking the treatment that he needs. He does want the court to know that he's pursuing his GED classes while he's in the jail. He does understand that the recommendation here is for additional incarceration. We are asking the court, rather than to order additional incarceration, to sentence him to probation after today. He does have 159 days of jail credit. He is within his guidelines if the court decides to do that. If the court wants him to sit longer, he does want to ask for either trustee or work crew. He does want the court to order him into CBT programming. I think that's an indication that Mr. Chap is taking this very seriously, and he understands there's going to be consequences today, but he wants to continue to better himself while he's facing those consequences, if that makes sense. So, Judge, for all those reasons, with his limited history, with his young age, with his obvious substance use issue, we're asking the court to time serve him today, put him on probation, order him to get a substance use assessment, and to participate in that treatment as he is ordered to do so. Thank you.
Thank you, Mr. Chap. You don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
Yes, if I could apologize to.
Go ahead and stand.
I would like to apologize to the victims for my actions and would like to let them know that once I'm out of here, I'm going to get the mental health and the drug abuse and alcohol abuse assessments and the help I need so I can better my life, and so nothing like this ever happens.
Okay, you've been on probation twice before, right? So you had chances to do all that in the past.
That's right.
Okay. You have a seat. Ms. Friedrich, any recommendations from the people?
Oh, yes, thank you, Your Honor. We're here because on December 18th of 2025, the defendant engaged in an argument with someone and held up what she perceived to be a gun at Speedway. He then left the scene and crashed his vehicle. He then became irate with his passenger and family members who tried to help him and began threatening them and started throwing punches. His blood alcohol level was at 0.186. He admitted to using marijuana that night as well as the alcohol. He's 23 years old. His first police contact, I was surprised to see, was 10 years old. As stated, he has 1 felony and 3 misdemeanors. He's unemployed with a 4th grade education, but he's pursuing his GED while incarcerated. His guidelines are 0 to 17, so this could be a prison case considering the significant public safety concerns that were caused by his decision and actions that night. However, I believe that the PSI recommendation for 1 year of jail with credit for 159 days is measured. I would ask the court to follow that recommendation. He can continue with his substance abuse meetings while at jail. And he is over 21, so I believe that prosecutor consent is required for a HIDA, and we have declined to offer that due to the serious nature of the offenses. Thank you.
Okay. I mean, you said held up, was she perceived to be a gun? Do you have any greater clarity on that? I mean, I thought there was a firearm
was found in the vehicle, so it's believed to be a gun. He said it was a pipe.
But there was a gun in the vehicle?
Yes, muzzle loader.
They did recover a muzzle loader.
Okay, which is a gun?
Yes.
It's a firearm.
That is a firearm, definitionally speaking, yes.
Okay. All right, thank you. Mr. Chap, if you please stand for the court sentence. All right, well, Mr. Chap, you're 23 years of age. You have a prior felony, 3 prior misdemeanors. We've certainly seen worse criminal records in the court. The advisory guidelines are scored at 0 to 17 months, which would put me at a presumption of no incarceration, but probation instead, unless there's some reason for incarceration. Here, I think there are reasons for incarceration. The public safety risk, firearm crime, your recent or your prior efforts on probation recently, and that were not good, and the fact that there was a felony firearm charge that would have had a mandatory minimum 2 years that you benefited from the plea agreement. All of that in the mix, I think some incarceration is certainly appropriate. In this case, I find it really troubling. You're driving drunk at more than twice the legal limit. And then you're engaging in road rage, confronting some other driver at a gas station, and you're pointing a gun at her. I mean, you don't remember. So, and there's a gun in your car. So guess what I believe? You pointed a gun at her. That's what she says. You don't remember, and there's a gun in your car. That adds up to you pointed a gun at another person because you're drunk out of your mind and mad. And then you take off, continuing to drive drunk and crash your car. People show up, some family members and some members of the public, and you threaten to kill them. They're trying to help you get your car out. Your prior criminal history, although I said it's not, extensive, it includes a prior impaired driving. It includes drugs, and it includes a prior assaultive crime. You've been on probation before in 2021 in Missaukee County. Unsuccessful discharge. I had you on probation from 2023 until last summer on a drug case. You didn't violate probation, so you got a successful discharge there. And then 6 months later, you're doing this. So I agree with the Department of Corrections. Why would I put you on probation? You didn't succeed before, and then when you did succeed with me, 6 months later, you're pointing a gun at somebody drunk and ticked off. The people in the community are entitled to think, are entitled to go about their day without some drunk, angry man pointing a rifle at them. A lot of times when people are pointing guns at people, I'm always thinking, is this a prison appropriate case? And I mean, I kind of think it is. So it's a real close call on whether to give you a year in the county jail or send you off to prison. I think, the prosecutors not pounding the table for prison here today. They think that the year in jail is a measured response and that that's appropriate, proportionate. It's hard to disagree with that, especially given your relative youth. So as I said, it's a very close call, but I'm going to follow the recommendations from the Department of Corrections. I'm going to order on the felony charge, you do 12 months in the Sheboygan County Jail with credit for 159 days previously served. I'm going to on the misdemeanor charges, or you serve 93 days in jail on each of those with credit for 93 days served. There's $168 in state cost, crime victims assessment of $130. There's court costs of $350. Yeah, I'm not going to approve you for any. I mean, you'll get good time credits in the jail if you don't misbehave back there, but I'm not going to give you any additional credits. We'll see how important these things are to you. If you want to do GED, do it, but you're not going to get any time off your sentence. Okay. So that's a sentence within the advisory guidelines. I think it is proportionate to the circumstances of the offense and the offender for the reasons that I've placed in the record. Mr. Chapp, if you want to appeal, you can file an application with the Court of Appeals. If you want a lawyer appointed, you have to make that request within 6 months. I'm going to ask you, we're going to hand you a piece of paper about those appeal rights, ask you to initial one copy so we have a record that we gave it to you. And the other one is for you to fill out if you want to take an appeal. Now, generally, Mr. Chapp, when somebody's in front of me and I give them a talking to about you're on the borderline of prison, when they come back, what do you think happens? Yeah. And so hopefully I won't see you back here. All right. Good luck to you. Oh, I'm sorry. There's also $225 in OWI restitution And the weapons forfeiture, we were not doing the weapons forfeiture, is that
We would
correct?
ask that it be ordered to be returned to the owner, Robert Stilla.
Okay, weapon will be returned to the owner, Robert Stillwell. Is this Mr. Swanson?
Yes, sir.
All right, bringing this lawyer here. All right, next we have People v. Donald Swanson. It's filed 26-7159FH. Counsel, you want to state your appearances, please?
Elsa Goodrich, Sheboygan County Prosecutor.
Good afternoon, Your Honor. Edward Bajoka appearing on behalf of Mr. Swanson.
All right, good afternoon, Mr. Bajoka. We've got Mr. Swanson here in the courtroom. The jail arraignment rooms are in use for arraignments in another court right now. So if you do need to talk to your client, just let us know. We're here for a docket call, which I use as sort of a jury status conference to see, kind of get a status of the case. Is it resolved? If not, do you want more time to see if that's possible? Are there any motions you anticipate filing, or are you ready for this to be placed on a trial docket and look at getting you some dates? So where are you at in that regard, Mr. Bajoka?
Your Honor, I think there are a couple of motions that need to be filed. We are have just received the preliminary exam transcripts, I believe, last week or the week before, but it was relatively soon, not too long ago. I think the primary motion that we're going to be arguing is related to some 404B evidence that I believe the prosecution intends to introduce. So that will need to be litigated. I think that's the primary hurdle to setting this for a trial date. I don't know what the court prefers, setting it for a trial date and a motion cutoff / hearing date, or if you'd rather hear the motions before setting it for a trial date. But unfortunately, we are not in a position for to resolve at this point.
Okay, yeah, I generally like to get us in a posture where everything's ready to go and then give you a date. So I'm not setting a bunch of sort of phantom trial dates. I'm one judge for 2 counties on the criminal docket, so I like to, if I set a trial date, have some confidence that it's going to go. So why don't we, now your motion, that would not require an evidentiary hearing, is that right? So that could be on my regular motion docket?
I believe so, Your Honor. I don't believe it would require a hearing. Correct.
Okay. I've got dockets the next couple weeks, but that might be kind of tight for you. And then June is kind of weird. So I've got June 2nd and 9th, and then not again until July 7th. I could give you the July 7th, so you've got time to write a motion and notice it up. But I could get you in the next couple weeks if you want to press it.
Your Honor, I hate to do this, but can we go out to a little bit after that July 7th date? Next week, I do have a trial here in Detroit, and the week of July 7th, I have another trial.
That's okay. I've got a criminal docket on Tuesday, July 21. Does that date work for you?
That works perfectly for me, Your Honor.
Do you prefer morning or afternoon? And if it's not an evidentiary hearing, I would allow you to appear by video if you wish.
Thank you, Your Honor. I appreciate that. Either one is fine. I'm wide open that day on the 21st.
Okay, well, why don't we schedule it for 11 a.m. on July 21st. And we'll have that be a docket call, and I'll also set it as a motion cutoff date for any non-evidentiary motions. If you decide there's a motion you want to file that is going to require an evidentiary hearing, just reach out to my assignment clerk and we can get you a special date and time for that. All right, but otherwise we'll be next on July 21, 11 a.m. and Zoom appearances are authorized.
Thank you very much, Your Honor. Mr.
Okay.
Swanson, I'll set up a Zoom meeting with you for probably Friday, sir.
All right, anything else from the defense?
No, Your Honor, just wanted to make sure Mr. Swanson heard my message.
Yes, he did. He acknowledged
Okay.
it, yes, and he's
Thank you,
nodding.
Ron.
Ms. Goodrich, anything further from the people?
Nothing further, thank you.
All right, well, we're all set on that file. You have a good day.
Thank you, Ron.
We can go off the record for a second. All right, we're back on the record. And next we have People v. Devin McLeod. It's two file numbers in file 22-6316FH. It's for a probation violation in an accosting case. 4-year statutory maximum, 2 to 17 months guidelines range. The probation violation is a non-technical absconding. And then in 7108, it's original sentencing on failing to comply with SOR duties. It's a 2-year high court misdemeanor. And the advisory guidelines on that file are scored also at 2 to 17 months. I've had a chance to review the pre-sentence report as well as some supplemental information submitted by IOSCO, adult education, an accident report, and a letter from the jail chaplain about his involvement in services. We've got Mr. McLeod with his attorney, Mr. Nightingale, in the courtroom, and the prosecuting attorney, Ms. Goodrich. Mr. Nightingale, have you had a chance to review the PSIR and the probation violation report with your client?
Have, Your Honor. Found a few errors that need to be corrected.
Okay, in which one, the PSIR?
Yes, so CFJ 284, page 5 and page 6, they both indicate that Mr. McLeod has some juvenile history. Petition number 15-8525DL and then petition number 16-77. Mr. McLeod's mother did reach out to me questioning these convictions or findings, however the court would like to refer to them. And so I did reach out to the prosecutor, and she does indicate that those files are not his. And so I'm not sure why this history appears on his report. And speaking to Ms. Martin, it does appear that this is part of a prior PSI that obviously she has included. But nonetheless, those should be stricken from the record if they are not his history.
So, Your Honor, the 15-8525DL was associated with another juvenile's name, so that's not Mr. McLeod's case. The 1677, those are that's an old file, so we had limited records, and we're unclear whether it was charged and then dismissed under a delay or not charged at all.
And you couldn't determine any, there are no no juvenile court records showing any adjudications for Mr. McLeod?
Right.
Okay, so H.M. Martin, would you strike those from the juvenile history based on that representation? And also that would have some downstream changes to the face sheet about juvenile record. Yes, we'll have to toggle no. Were any of those used in scoring prior record variable 5?
Here's it, 16-77 is marked as scored, so I would assume that's
one was not scored and one, the domestic violence, was scored.
correct.
So let's see, the other ones we had adult conviction 2 of 8 is a misdemeanor scored. A domestic violence in 2023 would be a scoreable misdemeanor. The I guess the Florida battery, that wouldn't be a prior misdemeanor? Is that correct? That wouldn't score? So we're looking at 2 scorable misdemeanors then? Ms. Goodrich?
I would agree with that.
So I think that would change it on prior record variable 5 from 10 points to 5 points, Mr. Nightingale. Ms. Curtis, do you agree?
Yes.
Okay. Did you have any other scoring challenges, Mr. Nightingale?
No, Your Honor.
Okay, so that brings that to 25 total points. And on the F grid, doesn't change the range at all. It's F. No, it'd still be, wait. Nope, that would still be prior record level D, so it wouldn't change the range. But that does clean that up. Okay, any other additions, corrections, Mr. Nightingale?
I just would like to add as well, that Mr. McLeod has, been engaged in GED classes while in jail. It is my understanding that, I think last week he completed his GED.
Okay. All right, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Nightingale, anything you want to say in your client's behalf?
Yes, Your Honor. Thank you. So Mr. McLeod comes to report 26 years of age. He does have 2 prior felonies, and I believe the 5 misdemeanors will still be accurate. No juvenile history, as the court has outlined. His guidelines are still the same, but nonetheless, I do think that with the reduction in his overall history, right, the court needs to consider that as a part of today's sentence. The recommendation on I'll still call it a pending case, is to serve 3 months, 3 days, Sheboygan County Jail. He's got credit for 238 days on that case with fines and costs. They're not asking to put him on probation. It appears that overall that the department considers Mr. McLeod not to be a good candidate for probation for these matters. Certainly can understand in some ways why that would be their opinion. Mr. McLeod obviously had some issues in complying with his reporting requirements. I think the court has received some documentation that Mr. McLeod went out to Maine, he got in a car crash, and I think if you would ask him, he felt very stranded. At a certain point, when folks are on these kinds of reporting requirements, it's almost a terrible idea to leave the state because then you sort of have multiple people potentially or multiple agencies that you then have to report to and to make sure that you stay in compliance with all of the agencies, not just one of them. And I know the court's going to look at me here in a second and say, well, he wasn't complying with any of them.
And he was on probation, so it's a bad idea to leave the state on probation without permission too.
Correct. A whole list of bad ideas here on Mr. McLeod's part. And I think at this point he realizes that this was a terrible idea for him and that he's gotten himself in a world of trouble when he could have just completed his probation successfully and moved on with his life. He still would have had these reporting requirements outstanding at this probation sentence, but nonetheless, he would not necessarily be in this compounding issue, I guess is what I'm trying to get across here. As for the probation recommendation, they're also asking essentially, I think, to time serve him to, not leave him on probation any further. He does 340 days of credit on that case. He is certainly served a good portion of what his guidelines would be on both matters. And the pending case has got a 2-year max. The probation violation's got a 4-year max. I think after 340 days of sitting 238 days continuously, that Mr. McLeod has certainly gotten the point. I think the longest he's ever sat in jail has been about 3 months. This is well in excess of his longest stay. And to Mr. McLeod's credit, he's never once asked me to address bond for him. He's never once asked me to try to send him somewhere so that he didn't have to serve his time. I think he knew that he was going to end up sitting for this for some period. And he's trying to front load this punishment for himself so that he can ideally stay here rather than going to prison. We're asking the court to keep him here. He does have significant credit at this point. We do not want him, I don't think, placed back on probation. He does know that he's got to continue to comply with his reporting requirements in the future. He does have some outstanding issues in other states at this point that he's also got to address. He understands that. He knows what he's got to do that, and to stay compliant with his requirements here while he's handling those issues. And so, Judge, what we're asking today is to time serve him, order him to pay some fines and some costs, not put him on probation any longer, and let him go address these other things that he needs to resolve so that he can continue to move forward in a productive fashion. He does have, I think, some employment lined up. He was employable and is still employable at this time. I know he wants to get back to work. He's finished his GED. I mean, he's doing good things for himself while he's been back there. And so I think the court should be aware of that and consider that in his sentence today. He also has good family support. His mother is pretty consistent about reaching out to me. And so I think that he would have good support going forward if the court were to decide to release him either to probation or no probation. We are asking the court not to send him to prison today for a variety of reasons, but for what I've outlined. Thank you.
Thank you, Mr. Mengele. Mr. McLeod, you don't have to say anything, but you're welcome to. Is there anything you want to tell me or no?
Yes, sir. I'd like to apologize to you and the court. I have no excuses. I should have never left the state on probation, plain and simple. It was immature and one of the dumbest mistakes I've ever made. I'm disappointed in myself, and so is my mom and grandparents. I was raised to make better decisions than this. I've struggled with alcoholism for some time now, and it's done nothing but destroy my life and hold me back from reaching my goals and becoming the person I want to be. When I lost my daughter, I relapsed, and it led me down a dark path and a series of poor decisions I wish I could change. I've recently completed my GED while incarcerated, and I really look forward to being able to pursue college and start turning my life around. This isn't the road I want to continue down. I have the chance to be a part of my daughter's life again, and I want to be a good role model and father and succeed while I'm young. I just have to start thinking about what really matters to me. I understand the severity and deeply regret my actions, Your Honor. I flew back from Maine to turn myself in and take responsibility of them. This is just a bump in the road, and I pray to overcome it, continue my recovery, and move forward in a more positive light. Thank you.
Thank you, Ms. Goodrich. Any recommendations from the people?
Yes, Your Honor, I think the defendant is 26 years old and unemployed. As discussed, his guidelines are 2 to 17. The PSI recommendation is for 12 months with credit for the 238 served. I'm in agreement with the recommendations. While the 12 months is higher than usual on a failure to register on the sex offender registry, we don't have someone who simply locally forgot to update their address or didn't update their address, but instead he went to 2 different states for his non-compliance. So I'm in agreement that 12 months. As to the probation violation sentencing, that's a different type of case. The underlying offense involved having sex multiple times with an underage female. He took no responsibility looking back at that PSI at that time and blamed the victim, saying she lied about her age. Probation never was taken seriously after by his actions. What's concerning here is in the probation violation sentence report, he scored high on the sex offender assessment. He was required to complete a 52-week program and he didn't do it. He was removed for poor attendance and then was asked to re-enroll, and he didn't. He left. So he's still high on the sex offender assessment with no classes or services offered to address that, which makes him a continued public safety risk. In June of 2024, the defendant had stopped reporting to probation. He left the state without permission. He was found in Maine. He had crashed his car in a head-on collision. He was found passed out on a sidewalk from intoxication. He also went to Florida and committed a crime, battery, and petty theft. For those reasons, Your Honor, I would ask for the high end of the guidelines on that case, which are also 2 to 17. Thank you.
All right, thank you, Mr. McLeod. If you want to stand for the court sentence. I guess first we'll address the probation violation. Mr. McLeod is placed on probation for accosting a minor for immoral purposes, which have been pled down from more serious, as the prosecutor indicated, sexual penetration offenses with a minor. He pleads to the accosting with 4 years. We put him on probation. That was quite an opportunity. And then Mr. McLeod doesn't comply with sex offender treatment. He gets a domestic violence misdemeanor crime. I don't revoke your probation then. We continue to try to work with you. And then you leave the state, violating your probation, and also then violating the requirement that you comply with the sex offender registry. So here we have a sex offender who's high risk, not engaging in treatment, not being supervised, and going to 2 different states and not registering in any of these states and causing, it's not like you were in those states earning your degree or doing good. You're in those states causing problems for those folks, crashing into somebody. Sounds like you were drunk. I don't know. Committing a crime in Florida. When I place somebody on probation, none of that is what we expect, right? Not a drop of that is probation behavior. So, I mean, obviously I have to revoke your probation. And we're going to reassess any fines and costs that were previously assessed. And they're reassessed in the amounts of any balances unpaid that are due and owing. And the guidelines at 2 to 17 in the absconding case, I'm not even bound by those because they don't take into account your abysmal performance on probation. I mean, you committed crimes on probation here that I didn't revoke you for, and in Florida, and you got an outstanding warrant for failing to appear on a charge in Maine. Yeah, I think given what you were on probation for, given your complete lack of engagement with probation, absconding supervision to other states and causing problems in those states, I am going to commit you, Mr. McLeod, to the Department of Corrections. It'll be for a term of not less than 2 years, nor more than 4 years. That is an upward departure from the guidelines. The reasons for the departure are your poor performance on probation, as I've outlined on the record. You have credit for 340 days that you previously served in that file. And in file in file 25-7108 for failing to comply with the sex offender registration duties. It's a 2-year maximum. Oh, that other one was 24 months to 4 years was the maximum. And this one, again, this, as the prosecutor outlined, this is more than just, failing to update. You're here, but you forgot to update something when you do your check-in. Here you were in 2 different states and you were causing problems in those states. So for that, it is within the advisory guidelines. I'm going to commit you to the Michigan Department of Corrections for a term of not less than 13 months, nor more than 2 years. Give you credit in that file for 238 days previously served. There's $68 in state cost, crime victims assessment of 130, and court costs of 350, which is far less than the average per case cost as calculated by the State Court Administrator's Office. And those 2 files, the sentences will run concurrent with each other, so they're not going to stack. And Mr. McLeod, in both those files, you can file an appeal if you wish, an application for appeal. If you want a lawyer, you'd have to ask within 6 months. So we're going to hand you 2 pieces of paper in each file. Ask you to initial one in both files. So we have a record we gave it to you. And the other one is for you to fill out if you want to take an appeal. So you are going to go to prison, Mr. McLeod. It's not going to be for a long sentence. And hopefully it'll be your last sentence. But the track record you've shown me is that's probably not going to be the case. And they don't tend to get shorter. So when you're back on parole, comply with parole. And I hope you do the good things that you intend to do, that you say you intend to do. Otherwise, we'll see each other again. All right. Good luck to you.
Thank you, Your Honor.
Does that conclude your matters? Mr.
It does, thank you, Judge.
Okay, that's good. I've got Mr. Hepner, but I don't see Mr. Muai. Mr. Gilbert, are you ready on any of your matters? We've got Mr. Joshua Hull.
He's out in the hallway? Okay.
Okay, I'll give you a minute if you need to talk to him.
Thank you very much.
Okay, let's go off record. Okay. When's the last time you've been convicted of anything else?
13.
Okay, in 2013. And yeah, that would have been misdemeanor stuff?
Yeah.
Okay. I prosecuted you for that, I think?
I think so.
Okay. All right, so that was more than a decade ago. Have you been arrested since that 2013 misdemeanor?
No.
Do you work?
Where you work small business.
You have your own small business?
Yep, Northern Power Washing Plus.
Okay. Do you have any employees?
Here and there. It's hard to get anybody to work nowadays, so
Okay.
I mostly do it by myself.
Okay. You have a home in Sheboygan County?
Yes, I rent a little house in Tower.
Okay. Do you have anybody that lives there with you?
Not at the moment.
Okay.
I had a wife, but she kind of left.
Okay. Do you have any criminal charges pending against you?
I do not.
Why is it that you'd like this conviction set aside?
It's just kind of been haunting me for a while in my whole life, just kind of sitting in the past here, and I know I screwed up way back then.
How old were
I
you
told my
back in
dad
90?
that. Pardon me?
How old were you back in 91?
Oh, jeez.
Well, how old are you now?
56.
Okay, so that was like 30 some. You were in your 20s?
Yeah, I was early 20, 21, 20, 21, somewhere right in there. Plus, I talked to my parents. My mom passed in 06. My dad, he was very sick, and I told him this is one thing I wanted to do for myself and for him. Well, he passed in January. So here I am still trying to honor myself and my parents, showing them that I did turn my life around, doing good.
Okay. All right, Ms. Goodrich, turn it over to you for any exam.
Involved in any community activities?
I am. I do a lot of umpiring. Got 32 years in the umpiring. For 6 years of high school now. So it's one of my passions. I do go to different functions for help kids. Kids are a big part of my life. I love teaching them how to fish.
No further questions.
Oh, it looks like back in 2020, I granted your petition to restore your Michigan firearm rights. Is that right?
Yes.
Okay. And since December of 2020, when I've done that, have you had any kind of police contact? Other than, I mean, I know you were the victim of a couple cases that we had in here.
Oh, yeah, that
But
was.
you haven't been charged with
No.
anything since.
No, sir.
All right, thank you. Ms. Goodrich, any position?
Well, Your Honor, I did not object to the relief requested.
All right, well, Mr. Henel, I find that you do meet the statutory requirements, and also I will find, based upon your testimony here today, that the circumstances and behavior of the applicant from the date of the conviction to today warrant setting aside the conviction, and that doing so is consistent with the public welfare. So I'm signing an order setting aside that felony conviction for you, Mr. Aaron.
Thank you.
All right, so we'll get a copy of that to you and to the state police. I'll indicate to the clerk's office, as I'm looking in the file, it looks like along with this application, there's some lien work that's in the public portion of the file. We can pull that and make it a non-public portion, anything that has lien. All right, good luck to you, Mr.
All
Hayes.
right, thank you.
Okay. All right, Mr. Gilbert, we could call, it will be Joshua Hull. This is file 26-71444F8. We've got Mr. Hull with his lawyer, Mr. Gilbert, present. Mr. Goodrich is the prosecutor here on the case. And Mr. Gilbert, we're here for a docket call. What's our status?
Yes, Your Honor, as I indicated on the waiver of arraignment, I believe a forensic center referral is applicable in this case. So I would ask for as to criminal responsibility and competency.
Okay. Okay, you want both?
I would like both.
Okay. They've been pushing us to see if competency will do the trick because they get so far behind in the criminal responsibilities, but we can, it's your right to request them both.
I guess if competency comes back one way, we will.
Well, then we usually can tell them to stop the other.
Right.
Okay. All right. Ms. Goodrich, do you have any countervailing information that would suggest that the court should not enter those orders?
No, Your Honor.
All right, so the court will enter the referrals to the Center for Forensic Psychiatry for evaluations as to competency and criminal responsibility. That takes it off of our time guidelines docket.
Your Honor, I'm sorry to interrupt. I believe his guardian might be in Zoom.
No.
Okay,
No, there's
okay.
nobody in Zoom, sorry.
So I said, sorry.
So we'll schedule this then for a status conference rather than a docket call. And we'll set that out. Let's put that out to September 1st at 2 p.m. All right, anything further from the defense?
No, Your Honor, thank you very much.
Anything further from the people?
No, Your Honor, thank you.
All right, so I'll entrust you, Mr. Gilbert, to make sure Mr. Hull is aware of any of his bond conditions between now and then.
Well.
But if there's no problems, we'll see you back September 1st or sooner if we get a report.
Thank you very much.
Yeah. Let's go off the record for a minute. All right, we're back on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And up next, we've got people of the state of Michigan versus Camden Hepner. Looks like we got 3 file numbers, a probation violation hearing in 24-6921FH, a sentencing and bond violation matter in 25-7087FH, and an arraignment in 26-7154FH. Counsel, you want to state your appearances, beginning with the people.
Melissa Goodrich, Sheboygan County Prosecutor.
I'm sorry, you're muted, Mr. Mawad.
Your Honor, sorry about that. Elias Mawad appearing on behalf of the defendant. I want to apologize. I was just finishing a sentencing in Ottawa County, which started at about 2 o'clock. So my apologies for being late.
Okay, no, and I appreciate we ended up sorting that out, so that we're good. All right. All right, so I know you just fairly recently appeared in these matters in my court. So I guess the easy thing is we got to arraign Mr. Hepner on the new charge. But
Correct.
Before I do that, we've got a probation violation, which seems like the predicate facts for that violation are the new charge. And we also have a sentencing on the dangerous weapon. We could either sentence him on that now, but the problem is then credit in the other cases would stop. So generally, I'm amenable to adjourning that if you wish to kind of deal with them all together. So before we go forward with the arraignment, what's your preference about that? To move forward with the sentencing and the probation violation, or both, or neither of them?
Judge, I did talk to the prosecutor this morning. We have both agreed that this matter, we'll handle the arraignment and then adjourn out all 3 cases to hopefully global resolution when we come back next time.
Okay, very good, very good. All right. So have you had a chance to review the charging document with your client in the new file?
Yes, Your Honor.
Do you or he wish to have its allegations read on the record?
No, Judge, we would waive the reading, sir, and stand mute.
All right, we'll enter a plea of not guilty on your client's behalf to the charge of malicious destruction of building over 1,000 with a habitual notice. Is a forensic center referral requested as to competency or responsibility?
No, not at all, Judge. I'll state for the record, I find him to be very confident, nice young man, actually, but thank you.
Okay. What would be the estimated length of trial in this file if it went that way?
I can't see it being more than 2 days. I'm not sure what the prosecutor thinks, but a day and a half, 2 days.
Okay.
Okay. All right, so we could schedule this for a docket call, and I'm a fairly Zoom-friendly judge, Mr. Mawad, so you can Zoom in for everything except if we get to a felony sentencing or if we get to a trial or an evidentiary hearing. I even will take a felony plea by Zoom, no problem.
Fair enough.
If we get up there. I could have you come back July 7. Does morning or afternoon work better for you?
Judge, we can do afternoon if that's okay with the court.
Yeah, that'd be fine. Let's do July 7 at 3 p.m. I'll allow Zoom appearances. You're always welcome in the courtroom if you wish. And then we'll also continue the sentencing in 25-7087 to the same date and time. And we'll continue the probation violation in 6921 to the same date and time. And Mr. Mawad, as you're new into the file, I'll just update you what Mr. Hepner already knows about me, that he and I have had some recent dealings and with the trial and the sentencing, and then these things being alleged on probation. And so at this point, I'm really starting to wonder whether local jail will do the trick for Mr. Hepner. So that would be your principal charge, I suppose, would be to get the cases and Mr. Hepner in a posture that I can be persuaded that we don't need to send him to the Department of Corrections at this point in his life.
I do hear you, Judge, and he did when we talk, he mentioned he has some history with you in a mature way, not in a grumpy way or in a, oh, woe is me way. So there is some maturity when I do talk with him, but I hear you and I appreciate you.
Okay, all right. Anything further from the people,
No, thank
from
you.
the defense?
No, Your Honor.
Okay, have a good day.
All right, Mr. Hefner, I'll be in touch with you. Thank you, sir.
All right, and then we can call the case of People v. Matthew Colpine. It's filed 24-6906. This is up for a status conference. We have a probation violation underlying, and we have a status conference as to competency. We had a hearing last time where we had, I think I had received the report, but Mr. Gilbert, you had wanted me to refrain from making any findings to give you a chance to determine whether you wanted a contested hearing. I mistakenly entered an order finding Mr. Colpine competent, and so I've rescinded and vacated that order. So we're back into the interim there. So how do you wish to proceed on that, Mr.
Your Honor, we're actually going to withdraw the objection at this point in time. I did do some investigating with the forensic group with the state, and it appears that they took Mr. Colpine off the list, and he's been waiting so long. We restarted his district court matter, and we'd asked the same happen here, because it looks like we just have to start all back over again based off of that evaluation. And I think the end result would be more beneficial than Mr. Colpine if we work out something or go to trial than continue down this path.
Okay, so I'll enter an order on today's date, finding. Well, Ms. Goodrich, do you have any proofs that you want to put in on the matter?
No, Your Honor, no objection to that.
All right, so we'll, on today's date, May 26th, based upon the most recent report we have from the center, I will find Mr. Colpine competent to go forward on the probation violation hearing. So we need to schedule that for hearing then and see if we get something worked out, or otherwise just to have a contested violation hearing. Is that what we ought to do next then?
I believe so, Your Honor. That would work.
Okay. What if we set it for June 9th at 3 p.m.? That'd be 2 weeks from now.
That should be fine, Your Honor. I think that would give us time to get a result.
Any objection, Ms. Goodrich?
No objection.
Okay. All right, so let's schedule that for a contested probation violation hearing on, say, June 9th at 3 p.m. But then be in touch with Mr. Gilbert whether, if you get something worked out that you don't need witnesses or whatever. But otherwise, we'll schedule it for a contested hearing and just set aside some time there.
Thank you very much.
That way, because he's in custody, we can just get it taken care of and see where we're going to go.
Sure.
All right, you're all set today, Mr. Colpine. That's really all. I mean, Curley and Dotter later are just bond forfeiture hearings that we continued for the bondsman. So I would require your presence unless you have something you want to update.
I haven't. I did try calling both of them.
Okay. All right. So does that conclude your matters?
It does, Your Honor.
Okay. Let's go off the record. Thanks, John. Petition.
Luke Gustin on behalf of Andrew Rusinger.
Melissa Goodrich on behalf of Secretary of State.
All right, and so this is a driver's license appeal on an appellate review. I did have a chance to review the record, including the administrative order and your petition, and then the brief that you submitted. So go ahead with any oral argument you wish to make.
Thank you, Your Honor. And I guess I'll keep it brief. As it looks like the Secretary of State hearing officer did in their decision to place Mr. Rusiger on, I guess, the restrictions of the interlock device. The hearing officer points out multiple drunk driving offenses, been sober since 2009, 7 from any marijuana or any other use of substances. He's been to AA, he's been to rehabilitation. He's got great letters. He's got a passing drug screen that he's also submitted. He's been abstinent, and he remains that way for his son. I had the fortunate privilege to coach his son in hockey. He's an outstanding young man, but it doesn't articulate any substantial or compelling reasons to even place him on the interlock device. It just states, well, based on our opinion, we think it would be proper that he be placed on these restrictions. Further monitoring is warranted for public interest, is what the hearing officer actually determines. Then further on says restricted license is approved at department to monitor petitioners' continued recovery from substance abuse, dependency, and/or provide them an opportunity. She has required the ability and motivation to drive safely. Well, wasn't that what the hearing was for? Was my question as I read that decision, because he's provided letters of support for sobriety. He's maintained his sobriety. I'm not sure I've known of any individual that says, well, I've been sober for 10 years and can go down to 8,963 days or whatever it was to the day of newest sobriety date. Right there, I knew he was serious about his sobriety and serious about the continuing of his sobriety. And I think it's important to note that MCL 257.323 reasons to set aside a conviction is the decision was not supported by substantial compelling evidence on the record as a whole. So I don't think this hearing officer articulated, and I think the evidence on the record as a whole, as we're looking at it, Your Honor, certainly supported giving back the full license outside of restrictions as opposed to placing him back on restrictions. So we've brought this appeal asking the court to find that the hearing officer's decision was not supported by substantial compelling reasons. It was, I guess, an abuse of discretion and clearly an unwanted exercise of that authority of the hearing officer to put him on those restrictions. Thank you, Your Honor.
Can I ask you
Yes.
it seems like the two, I grant you that the order is fairly brief, but it says the petitioner's been diagnosed with an alcohol dependence disorder. He has multiple convictions for impaired or intoxicated driving, and he has a relapse history. A restricted license and the monitoring of his recovery is warranted and in the public interest. I mean, obviously, you'd have multiple convictions or you wouldn't be there.
Sure.
So it seems like the two facts that the hearing officer relied on to impose the restrictions in the interlock were the alcohol dependence diagnosis and the relapse history. But when I looked at the substance abuse assessment, it doesn't say alcohol dependence. It says alcohol use disorder severe. Do you know what's the delta between those two? Is there a difference and what is it?
Well, I think the alcohol severe, and I saw that as well, Your Honor. I did see on the substance abuse evaluation, it diagnosed him with cannabis use disorder, but it was an excellent prognosis. I wasn't sure, and I guess I would have to look back to see what the prognosis was with the alcohol disorder.
It was sustained full remission.
Yeah, so in my opinion, I thought that was an error in the appellate judge's decision or the hearing officer's decision into saying that, okay, he has this diagnosis. Well, most alcoholics do will have that diagnosis, but it's in sustained full remission. It wasn't that it was in partial remission or not in remission at all, that it was still something that was a problem, but it was in sustained full remission. So I think that's where the difference, in my opinion, would be or would fall.
All right, thank you. Ms. Goodrich, the Secretary's position?
Your Honor, I believe that it sounds like both parties agree with the factual findings as outlined in the order, but how they're applied. So I'd ask the court to find no abuse of discretion as stated that they believe that the restricted license would monitor his recovery, and would be in public interest.
I'd ask you the same question, I guess. The hearing officer's order says the petitioner has been diagnosed with an alcohol dependence disorder. But I didn't see that in the record. What I saw, the diagnosis was alcohol use disorder severe. Is there a difference between the two? I mean, my belief is that there's a difference between the two. I don't know that I can articulate super well what that difference is or the extent of that delta. Do you have any thoughts on that?
That would be my same response, that I wouldn't understand what the difference, I guess, without being a clinician in that
I mean, so
area.
let's assume there's a difference, because I think alcohol use disorder, whether it's mild or moderate or severe, is talking about a disorder in how you use alcohol or abuse it. A dependence is a specific biological relationship between the human body and alcohol. So you can have alcohol use disorders without having a dependence on that substance. One is more of a psychological and one is more of a physical. So let's assume that there is that difference. Does the hearing officer's error about that undermine the finding of a restricted license, or is that still justified because it's a severe alcohol use disorder? What's your thoughts on that?
I think it'd be difficult to try to read as to how you're saying what those differences, but what the hearing officer, if he would agree that that's the difference he was saying in his mind when he wrote this.
Okay. All right, thank you. Any rebuttal argument, Mr. Professor?
I would just say that, I guess dependence to the use disorder where there's no evidence of any use or that there's going to be any use, really is a null point by the hearing officer, and I think it's misplaced in this decision and in this order. When you look at the assessment itself, okay, he has an alcohol abuse disorder, but there is no dependency, there is no abuse at this time, and he's in sustained full remission from that, Your Honor. So I think there is a fine line and a distinction between those.
All right, well, this is an appeal. I'm to decide this based upon the record and review the decision of the Secretary of State for whether it's in violation of, or whether it's supported by competent material and substantial evidence on the whole record, or whether it's arbitrary, capricious, or clearly an abuse of discretion or an unwarranted exercise of discretion. In this case, Mr. Rugziger had shown clear and convincing evidence that his substance abuse problems were under control and likely to remain under control to the extent that the Secretary of State did restore driving privileges to him, but did impose a restricted license, including with the interlock, and then he has to petition at a later date to get that changed. I don't really have any briefing or description or argument in front of me about, well, what standards do they have to consider with whether to impose that restriction, other than I think it's a discretionary matter, but it's got to be based on some evidentiary fact. I don't think it would be proper for the Secretary of State to just take the position that all licenses, when they're granted, first have to be given in that fashion. That would be them sort of changing the statute. Here, the hearing officer did find 3 facts that were articulated that supported the restricted license to monitor his recovery, that the hearing officer said was warranted in the public interest. 1, because he had multiple convictions for impaired or intoxicated driving. Well, that's not really an important factor, because obviously you would have those, or your license wouldn't be revoked if you didn't have multiple drunk driving convictions. So that really wasn't a reason. But then the relapse history, which he did have a history of periods of sobriety and then relapse, and then the alcohol dependence disorder. I don't find in the record that there was a finding of alcohol dependence disorder, but there was a finding of alcohol use disorder severe, and that was in sustained full remission. I think there is some room for a hearing officer to look at. For example, the cannabis use disorder was mild and in sustained full remission. It could be possible for somebody to have an alcohol use disorder, mild or moderate, and get a couple drunk drivings And so it seems not irrational for the hearing officer to treat a severe alcohol use disorder differently than a mild or moderate one. So where I struggle on this record is that, you know, some of the hearing officer's reasons really weren't well-founded or were based in a bit of a mistake on the record. But I do see there was a severe alcohol use disorder finding. And what I'm, like, if I was the hearing officer, I think I give him a full license. I think I do. But I'm not the hearing officer. And I don't know that where he's got a relapse history and a severe alcohol use disorder, that it's really staying in my lane to say that that's an abuse of discretion or not based upon any competent material evidence on the whole record. So I think on the standard of an appellate review, I'm going to deny the appeal and uphold the decision of the Secretary of State. I'll check the boxes on that order and we'll get that filed and sent out.
Thank you, Your Honor.
Thank you.
Over there, there's 2 copies. All right, now brings us next to sentencing and People v. Eric Myers, file 26-7133 FH. Counsel, you want to state your appearances, please?
Mr. Goodrich, Lynn County Prosecutor.
Thank you. I'm very much on behalf of Mr. Myers, who's just here.
All right, we're here for sentencing on a charge of accosting a minor. It's a 4-year felony. The advisory guidelines are scored at 0 to 9 months. I have reviewed not only the pre-sentence report, but also a defendant's written sentencing memorandum, written victim impact statement, written letter from the parent involved, and also, so I've reviewed those matters. Mr. Gauthier, have you had a chance to review the pre-sentence report with your client?
I received the report, reviewed it with my client, Judge. We don't have any additions, corrections, or deletions to the body of the report, and no challenges to the guidelines, and it's accurately scored 0 to 9.
Okay, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Okay, and we do live stream these hearings, but obviously due to the sensitive nature and the ages of the age of the victim, I would remind folks to take every effort to avoid using any name that would breach that privacy consideration there. So, Mr. Gauthier, is there anything you want to say on behalf of your client?
Just briefly, Judge, my client is 18 years of age. The incident alleged here occurred when he was 15, maybe 16. And over the last 3 years since the incident occurred, there have been no violations or any of this conduct exhibited by Mr. Myers. We did do a risk assessment that was helpful in plea negotiations. And certainly with Mr. Myers, with his treatment, with some help, with some counseling, I don't see him to be a problem going forward. I think he acknowledges and understands the wrongdoing as well. He's apologetic for his conduct. And again, I think this is harder on family than as a whole. And Mr. Myers understands that as well. He does not have his high school diploma or a GED. Mr. Myers indicates it's his goal to get his GED. He wants to go into trade school. He wants to work in the construction line. Hopefully eventually getting his builder's license, and that's what he wishes to do. I think Mr. Myers, in discussions with him, is mature enough to understand all the logistics that goes into construction. He's mature enough to understand what he needs to do to accomplish the goals that he has, earn a living, take care of himself. And he's going to be 19 here fairly soon, and it's easy to say he's an adult and figure it out. But he's, in my opinion, still maturing as a young child and growing into the adult world, given some of his traumatic history with his history that he comes through the abuse and neglect case and the adoption issues that brought him into his current family. So I think
when you look at the totality of everything Mr. Myers has been through and why we're here, I don't want to say it's not a surprise, but I think Mr. Myers understands that he has to deal with this trauma. He has to deal with the underlying trauma. He has to deal with the trauma that this case has brought him here before the court. And he has to work with some of his demons that he has as well. But it's all doable when you review the assessment that was done for Mr. Myers. I know Mr. Myers is asking that he be allowed to go home. I will leave that at the court's discretion, but I would advise Mr. Myers that I don't think at this point that's a good idea for him to do so. I think that sets him up for failure. Certainly the goal is not to set him up for failure, but for Mr. Myers to be on probation and work through therapy. And again, if we have a therapist who can opine that there's a certain time frame where he's worked for Mr. Myers and he can go home in a safe manner, certainly I would ask the court to consider that. But at this point, I would simply ask that the court file the plea agreement. 9 months is the high end of the guideline range, albeit it is advisory that the court can certainly go to the top end of the guidelines. I would ask the court to give him the 238 days credit so that he can be released now and work on getting his life together and getting his GED. I know Mr. Myers has also indicated that while incarcerated, the jail gives him a tablet. And on that tablet, he has taken steps to take some courses and learn some ways of, again, bettering himself. So all of those things over the 238 days that he spent in jail, he's taken steps to better himself and learn some ways to again, look forward to being out and being a productive member of society. So for those reasons, I'd ask you to follow the agreement in this case. Thank you.
All right, thank you. Mr. Myers, you don't have to make a statement today, but you're welcome to. Is there anything you want to tell me or no? Ms. Goodrich, any recommendations from the people?
Yes, Sean, thank you. We are here because the defendant had sexually assaulted a family member more than once and had talked about it at school, which brought it to light. After then, the victim was interviewed an initial time after the defendant was removed from the home and incarcerated. The victim went through a second interview and made further disclosures. The defendant is 18 years old. It looks like his first police contact was at 16 years old, but he had no prior criminal history. He has an 11th grade education. He's currently unemployed. The guidelines are 0 to 9. We had a plea agreement to a 1-year county jail cap. The PSI recommendation is for 1 year jail with 5 years probation. I'm in agreement with that recommendation. There are some mitigating factors here that the defendant was between 15 and 16 years old at the time of the offenses. I had also reviewed the risk assessment before extending the plea offer, and that gave more insight as to the defendant's past traumas. I do not currently agree with the defendant returning to his household in the future. If there's some counselor intervention working with the family that can oversee that process and make sure that it's safe for everyone, then I may change my mind at that point. Thank you.
Okay. All right, Mr. Myers, if you please stand for the court sentence. Mr. Myers, you are 18 years of age with no adult criminal record. You do have some juvenile offenses. This is, a very serious matter. That was charged in the adult court by statute. The prosecutor has that discretion because you were older than 14, given that this was a criminal sexual conduct in the first degree charge. And, given the age of the victim and the fact that there was sexual penetration that occurred. So that on a first degree or even the second degree charges with a victim under 13, this case would have resulted in you going to prison for sure. And even with pleading it down to an accosting, the guidelines don't adequately take into account, really the seriousness of this situation, because the guidelines are scored for the accosting, but really what we do have here is a very serious criminal sexual conduct. So it wouldn't be all that unusual for me to send you to prison today based on that conduct. There's a pretty good case that that's what you deserve. The Now you were a minor at the time and the prosecutor has elected to charge this in the adult court. When that happens, I sort of give an extra measure of deference to any leniency that the prosecutor sees fit to extend. A, they know more about the case than I do, and B, they could have brought the case as a juvenile matter. So they've triggered my jurisdiction in this case is at their request, so to speak. So those are the reasons why I'm not going to send you to prison today, Mr. Myers. But this is a very serious crime. I don't know, given the, statements you were making at school, I don't know that you fully appreciate the seriousness of the crime. In any event, I'm going to place you on probation for 60 months. That's 5 years. That's a required term. And that's during those 5 years, you're going to be subject to the terms and conditions listed on pages 2 and 3 in the pre-sentence report. I want to highlight some of those, although all the terms apply. There's a crime victims assessment of $130, court costs of $350. You have to comply with DNA testing and pay a $60 fee. There's $68 in state cost. There's a monthly supervision fee to the Department of Corrections. You have to keep and maintain a job. You have to finish your schooling through a GED or adult education. You have to complete a psychological evaluation when you're referred by your field agent. You have to complete a substance abuse assessment and complete any treatment when you're referred by your field agent. You have to comply with the Michigan Sex Offender Registration Act. And I do note on this record that sex offender registration is required. And it looks like the department did help Mr. Myers accomplish that as of May 6th. So the SORA registration has occurred. You have to comply with all the requirements of SORA. You have to complete sex abuse programming or other treatment when you're referred by the field agent. You can't have any contact at all with anybody 17 years of age or under, except with written permission ahead of time from your field agent and certain parameters around that. I'm also going to, do we have the, okay, yes, we've got the internet and computer terms. Okay, so you've got to comply with a whole bunch of rules with your supervising agent about internet and computer. You're going to be very restrictive. And also I am going to order that during that 5 years, you have no contact whatsoever with the victim in this case. You don't go home to where she's at. You got to find yourself somewhere else. You're 18 now, and gee, that's kind of tough to be on your own at 18, but you did that. I'm not going to place you back in the home of the person that you abused. If you have any contact with her, I will send you to prison. You understand that? A phone call, you'll go. I do find reasons to depart from the guidelines. They don't take into account the full seriousness of the situation. So I will order that you serve 12 months in the Sheboygan County Jail. I will give you credit for for 238 days previously served. I will indicate that if the jail determines you to be eligible, you can participate in GED programming in the jail and obtain some credit against your sentence if you complete your GET. That's the sentence of the court. If you wish to file an appeal, you can do so by filing an application to the Court of Appeals. If you wanted a lawyer appointed, you'd have to make that request within 6 months of today's date. We're going to hand you a piece of paper explaining those appeal rights, ask you to initial one copy for us. The other one's for you to fill out if you want to take an appeal. And within 24 hours of your release from the jail, you have to contact your supervising agent. Do you have any questions for me, Mr. Myers? Okay, good luck to you. We are providing public access both in the courtroom and also online. Change here, there we go. All right, and we've only got just a couple cases on our morning docket. First, we'll call People v. Spencer Hope. It's file 26-7142FH. Counsel, you want to state your appearances, beginning with the people?
Melissa Goodrich, Lynn County Prosecutor.
Danny Price for the defendant who sits to my right.
Okay, and good morning. All right, and this is the time and date set for a docket call on this matter. And Mr. Price, what's our status here?
Thank you, Judge. I have retained the services of an expert witness. Unfortunately, I do not have a report from that witness. He informed me that I may not be able to get it until the end of June. My client has maintained his innocence throughout from the day that he was arrested. That's going to show that that is the case. I've talked to the prosecutor who agrees that it's probably better if we have that report before.
Okay, is that like an accident reconstruction? Well, it's not really an accident, but is it a traffic expert or?
He does accident reconstruction throughout the state of Michigan. It's
Okay. Ms. Goodrich, any objection to that?
No, Your Honor. A review of that report may require the necessity for me to have an expert available as well. So I would need some time after we receive that report.
Okay. All right, well, that's good. And I know that the parties had submitted a stipulation to adjourn this for additional discovery, but we had already done that once, and the wording of the stipulation didn't provide any information to me that there was something new of this nature. So I thought, well, so that's why I didn't sign that. But if we're awaiting a retained expert report, that you said he's going to have the report done by when?
He told me that he should be able to have it to me by the end of June, which is why I would ask that July 7th, our next date.
Okay. Does that date sound good to you, Ms. Goodrich?
Yes.
All right, why don't we do July 7th at 10:30 in the morning?
Thank you, Judge.
All right, anything further from the defense?
Nothing
from the people?
All right, thank you.
Okay, we'll see you then, Mr. Hope. And I've got Mr. Cordes appearing by Zoom. Are you Mr. Evans? You can come on up to this table here, sir. All right, so you can have a seat. That's fine. All right, up next, we've got People v. DeAndre Evans, file 26-7138FH. Counsel, you want to state your appearances, beginning with the people?
Melissa Goodrich, Lynn County Prosecutor.
Jeff Cordes on behalf of Mr. Evans.
All right, good morning, Mr. Cordes. And Mr. Evans is present here in the courtroom with us. If at any point during the hearing today, you guys need to talk privately, you just let me know and we can try to facilitate that.
Thank you.
All right, so this is the time and date set for a docket call. And also, we do have a show cause for alleged bond violation for a couple positive drug screens. So, Mr. Cordes, have you received a copy of that?
I have, Your Honor.
Okay, so Mr. Evans, it's alleged that you're in contempt of court by violating your bond by testing positive for THC and cocaine on March 2nd and THC on April 7th and April 16th. Oh, there was a February 26th THC as well. So THC kind of throughout. I don't know if there's a medical card or something there, but there was a positive cocaine test confirmed from March 2nd. So you have the right to have a hearing on those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer at that hearing and to present any evidence in your own defense, cross-examine any of the witnesses presented against you. Also, however, if I develop reasonable cause to believe that you're violating the conditions of your bond, I can amend that bond or revoke it at any time. Mr. Evans, do you understand the rights that you have and the penalties involved on the contempt? Okay, Mr. Cordes, do you know how he wishes to proceed on that?
Yes, he'd like to enter a not responsible plea at this matter and set that for a hearing. We did provide some information to the court that I think would be appropriate.
Okay, so I'll enter a not guilty plea on the contempt and we'll schedule that for a contempt hearing. Where are we at on the underlying charge?
Yes,
Go ahead.
Your Honor. I received an email. I've been staying in contact with Mrs. Goodrich. She gave me some information yesterday. Excuse me. We've been able to talk about this, and there are still a few parts that I'm working on putting together. Ms. Goodrich did tell me that the court had another docket day on June 9th. I would ask if we were able to adjourn to that date. I believe we can have some type of resolution by that point.
Okay, any objection to that, Ms. Goodrich?
No objection.
Do you have any thoughts about or objection to continuing Mr. Evans' bond until that date?
Your Honor, the concern here is that he is here on a cocaine case, and so I'm more concerned about testing positive for cocaine. He was on probation and still is in another county at the time that he incurred this charge. So for those reasons, there was concern by the people.
Okay. All right, well, what I'm gonna do is this here. We'll schedule this for a continued docket call on June 9th at 11:20 in the morning. And because there was a show cause, you had to be here in person today. I will allow Zoom appearances at that next hearing if there's no further problems on the bond. I'm going to continue your bond, Mr. Evans, for now, but I guess I don't want you to tell me anything about the past violations are alleged. Your lawyers asked for a hearing, and that's fine. I just want to tell you, I don't want to see you testing positive for cocaine. If there's any more positive tests for cocaine, I'm probably just going to sign a warrant. And I imagine this case, if you go to trial and are acquitted, that's great. If you go to trial and are convicted or enter a plea, you know, you and I probably know this is probably a Department of Corrections case. So you want to remain free as long as you can to, you know, just take your things, right? So just follow the bond, and I'm happy to let that happen. I know, Mr. Cordes, it looks like Mr. Evans really wants to tell me something very badly. I suspect that you would like him to not do that, because Mr. Evans, nothing bad is happening to you right now. I'm not canceling your bond. Your lawyer, I'm sure, is worried that anything that comes out of your mouth right now might change that plan that I have. So I'd encourage you to just sit tight and talk to your lawyer about that, okay? Okay. I just wanted to caution you, I do expect to see no positive tests going forward. Okay,
That's fine.
okay.
Thank you.
All right, and we'll set it for a status conference on the pending contempt violation at the next docket call. Mr. Cordes, I do that rather than, you know, schedule it for a contested hearing, just to kind of monitor what's going on. If you decide that you'd like to proceed with a contested hearing, just let the prosecutor know, and she'll make sure to have witnesses available then, okay?
Okay, makes sense. Thank you, Your Honor.
All right, anything further from the defense?
No, thank you.
Anything further from the people?
Yeah, thank you.
All right, you're all set today, Mr. Evans. You have a good day. And that actually concludes our very late morning docket. We'll be adjourned until 1 p.m. All right, let's call next Studer v. Hines, file 24-9075NO. Being back on our civil docket, we are providing public access not only in the courtroom, but also online. And counsel, you want to state your appearances, beginning with plaintiff.
Judge Mike Flagstead, P number 79314 on behalf of Mr. Studer. Good morning, Your Honor. I'm Jack Deegan. I'm on behalf of the defendant. My P number is.
Oh, I don't require that sort of thing. Yeah.
He said it, so I
Yeah,
want to mention.
That's fine. You wanted to say you had an earlier one or a later one?
Yeah,
that-
no, strike that.
yeah.
You got me by 20,000.
All right. Thank you very much. All right, this is defense motion for summary disposition. And before we get into the merits of that, there was a brief, a response, a reply, and then a supplemental brief filed by the plaintiff. And Mr. Deegan, you have objected to that supplemental brief. You want to say anything about that objection?
I do briefly, and I don't normally file objections like that, but this is an important motion to me. And I do believe that their supplemental filing doesn't follow the court rules. Generally under 2119, I file a motion, they file a response, and then I get 5 pages to reply. Within their response to my motion for summary was arguments as to the work comp lien and also what it looked like a motion in limine, and then a couple paragraphs as to I-2. A lot going on there, 2.116 I-2, but I kept my response within 5 pages. So I was very surprised then when I got another supplemental response. And I did object. I can find no basis for that under the court rules. And so I filed that objection to preserve the record. That is the purpose of my objection, Your Honor.
Okay, thank you. Mr. Flagstad, what's your response to that?
Judge, I hope the court received my response, my written response to Mr. Deegan's objection. If it didn't, I'd be happy to.
I did. Yeah.
Okay. Judge, I do believe 2.116 G1A is the correct part of the court rules. And what G1A indicates is that when a party files a motion, gets a brief, the non-moving or responding party gets a response, and the filing party gets a reply. And Judge, I would indicate that's exactly what we did.
Yeah, except you didn't. You didn't file a motion. You filed a response to a motion, and in that response, you asked for partial summary disposition in your favor under what, I-2, where if it appears to the court that the opposing party rather than the moving party is entitled to judgment, the court may render judgment in favor of the opposing party. So it's perfectly appropriate for you to ask for that remedy, which you did. That doesn't make it a separately filed and noticed motion, does it?
I would agree, Judge.
So you didn't file a motion?
We did style our motion in brief, a counter motion in brief.
Right, by skipping the notice of hearing.
We found the notice of hearing.
Skipping the notice of hearing timing requirements, skipping the filing fee. I mean, you're filing a response and saying, my response is not only a response, but like 2 other motions, but I'm not going to file them as separate motions. That doesn't seem consistent with the court rules at all.
Well, I'm sorry, Judge, I'm jumping at the bit and I'm interrupting you. I apologize.
No, go ahead. And so I'm just wondering, then it looks like you're asking for here's an old fashioned word for you, a sur reply. There's a motion, a response, a reply, and then sometimes if the court allows it, a sur reply. But that seems to be what you were doing. Explain to me why I'm wrong about that.
Judge, we did file a notice of hearing with this time and date. It did comply with the notice requirements. I believe it was 24 days prior to today's date. We did submit a check, Your Honor, for a separately filed motion. There was a filing fee. We consulted with the clerk whether they would like an additional filing fee for the counter motion. I believe the answer was no. Furthermore, Judge, as we indicated on the face of that counter motion, if this action does not please the court, we would be more than happy to back off from that, separate out our motions, or have it heard another day, Judge. Certainly it's at Your Honor's convenience. If it is not convenient for Your Honor, we would be happy to separate that out. Our thought process, Judge, was kind of twofold. The 2116 subpart, which I can't cite off the top of my head, does seem to encourage consolidation of motions. And moreover, Your Honor, we'd be looking at essentially 3 motions and briefs across 2 separate days on the exact same facts and issues. That was plaintiff's thought process. If it does not please the court, if it is not convenient to hear our motions, we would be more than happy to separate those out to a different day, Judge.
Your response, Mr. Deegan?
Briefly, This is a simple process. This is the first time I've dealt with this kind of strategy and trying to get around the page allotments. And what I do believe is an attempt to make this confusing and try to indicate there's some issue of fact, which I'm going to argue there is not in my motion for summary disposition. What I heard was, okay, you got all this stuff in front of you now, but now I'll have a separate motion for partial summary disposition, a separate motion in limine. And that's not appropriate. What we're here for today is to argue my motion for summary disposition. They did say in 2 paragraphs, and I'm going to argue without basis that somehow they get dispositive motion under I-2. The fact of the matter is we have a bunch of paperwork. I hate filing objections, but I had to protect the record. There is no court rule that allows this type of procedural play. I think my objections stand or should be granted.
All right, thank you. Well, as a matter of the court rules, the defendant, I think, is absolutely correct. The plaintiff, in the response to defendant's summary disposition motion, could argue that they're instead entitled to summary disposition under I-2, but this doesn't trigger the option to file a SIR reply. To the extent that plaintiff's motion was styled as a separate motion of some sort, it wasn't filed as such. That practice did not comply with the court rules. Defendant's reply was the final brief on the only pending motion, the motion for summary disposition under 2.116 G1A, and no supplemental briefs may be filed without leave of the court under G1A4. Having said all that, I mean, I read it, and courts can disregard stuff that I strike, of course. But also, I guess I'll say, I don't recall if we've had a case, Mr. Klagstead. I'm not remembering it. So this, I'm taking as Mr. Klagstead's first appearance in a civil matter with me. And there are some areas where the court rule doesn't, cleanly address some issues. What I would prefer, Mr. Klagstead, you do when you've got questions like that is see if you can get opposing counsel on the horn. And I'm very amenable to phone conferences with folks to sort out issues like that. What does not please me is then when stuff is just filed and then there's a footnote dropped for me to let you know if you should do something different. I mean, how courts work is when you file stuff, I try very hard to be a judge who's prepared for court, which means I'm reading them in advance of court. But usually that's not a matter of several weeks before the motion hearing.
Understood.
So I'm reading this footnote at the same time I'm reading Mr. Deegan's objection to what you've done. So that sort of approach doesn't really give us time to sort that out. So because I'm going to give some grace and not strike the brief, but let Mr. Klagstead know, I think Mr. Deegan's absolutely right about those court rules. And in the future, follow those. Or if you want to do something different, pick up the phone and we'll talk. Okay.
I'm satisfied. Thank you.
Okay, very good. All right. So, and you can have a seat. You don't have to stand the whole time, and I let you argue from the podium or from the table, seated, standing, whatever you want to do. Mr. Deegan, go ahead.
Yes, Your Honor. And this is my motion for summary disposition. First of all, I do have a C8 aspect of the motion, and I won't go into great detail.
That's as to the count 2 negligence.
Yes, sir.
Which it seems to me would only survive if Mr. Klagstead was pointing out, hey, gee, you've raised a question about where this might have happened. And if it happened on the public area because of some improvement your guy put there,
possibly,
then that would be a valid negligence count. But it doesn't seem like anybody's claiming that's actually what happened.
No, and I cited some of the case law that would discuss that. For instance, if I had a piece of property near an alley and then something was flowing into that I caused, and then I do agree, but there has been no allegation of that sort. So I do request that count 2 be dismissed.
Or if your client had placed landscaping stones in the public beach area, the plaintiff accessed the public beach area and somehow was injured by the placement of those landscaping rocks, that could be a negligence claim.
There has been, that's possibly, that would, your hypothetical may make sense. However, there is no evidence that any of the landscaping rocks were put on public right away.
All right. It sounds like the plaintiff is maintaining that although some folks may have had unclear understanding or recollection about ownership or lines that the plaintiff's claim depends upon the fact that this happened within the easement.
It would, because with no evidence demonstrating that we breached any duty or even affected the public land, there is no argument as to a potential negligence claim.
Okay, and I know you pointed out some of those discrepancies about the location, just if it helps both parties to understand. I looked at all that and thought, there doesn't seem to me that those discrepancies rise to the issue of a genuine issue of material fact about the location. And I'm analyzing this as if the injury occurred on the servient estate of the easement, within the easement.
That is my understanding, Your Honor. And when you speak to issue of fact, that goes to C10 and has to count 1. And in this case, and you look at the case law, the burden is on them to show that he was not a trespasser. That is my allegation. This is an easement that has been in place a long time. The grantor of the easement is a lady named Diane Hayes. Her daughter is Dawn Bodner. The easement is simply for ingress and egress to the beach. That is it. Diane Hayes testified she never gave permission or authorized or asked Mr. Studer to come on premise. Her daughter also said, I never gave permission. My client certainly did. And then I have communication from counsel for the county that says he was not authorized to do this as a planner. With that being the case, this is a clear case of a trespass and an injury that occurred. My client never had any notice, certainly didn't have any idea, and understand that the rocks at issue here had been placed about a year prior. And they were for purposes of erosion. They weren't to prohibit anybody. You could still have access. So all the testimony is very clear that Mr. Studer, for some reason, found it appropriate to come onto this easement, which he is not a party of, and he found himself hurt, and now he sues my client. And that's inappropriate. Let's take it a bit further. If it's a trespasser, they have to show that we willfully or wantonly injured him. And
there's no indication of that.
There is none. If he's a licensee, we have to show that we knew of something that was dangerous, and we didn't take any care, but the duty there is quite limited too, as the court knows. And so with that being said, even if he is a licensee somehow, which I can't see, there's no issue of fact as to whether he's possibly a trespasser, let alone licensee. And I think it's been admitted that he's certainly not an invitee. Going forward, so there's no issue of fact, and the cases I've cited show that it is there in Tripp versus Baker, Allstar versus Glidden. Tripp versus Baker, the court says, where plaintiff failed to produce evidence creating an issue of fact on the point of a trespass, their case fails. There's another problem too, is just.
Mr. Deegan, I got a couple of questions for you.
Yes, sir.
What about I want to go back just a moment to the licensee issue and your argument, and it's in the briefs, that if the plaintiff is a licensee, your clients should still win because they had no notice of this defect, this hole.
And that
would normally, and you and I have had some cases that turn on that precise question.
We sure have.
And I know there's some merit to that as a general proposition, but in this case, it sounds like the facts are that the depression would be as a result of work that your clients did putting that in, by putting in the soil and the sod, and then it settles and there's the hole. So do those general notice rules apply when the defect on the land is a result of actions that the landowner took?
I hear you, Your Honor, and that is complete speculation in this case, because the next point I was going to get to, let me go back to licensee. First of all, a landowner owes a licensee only a duty to warn of hidden dangers known or with reason to be known by the owner if the licensee does not know or have reason to know.
Sure, so that gets to the, would they have reason to know if it was
Correct.
caused by their actions?
And now, that's why I had indicated to the court that these landscape rocks had been in place for a while. No one had ever said they had a problem. We had no reason, nobody said, hey, it's weird out there. And understand too, he stepped on the rocks and stepped off. But we've never had any indication. My client has used this. Diane Hayes, who is the grantor, and her daughter, they have never indicated that there was a problem. And the other issue too is you go to not only notice, but they don't even seem to know what exactly caused. He stepped off, maybe it was soft, maybe there was a hole. There seems to be speculation as to even what caused. Could it have been just simply stepping wrong? Happened to my neighbor last week, broke her foot. I don't know.
Well, and as to the notice, this is more a question for Mr. Klagstad, but it seems to me like, how would you have notice of that? Like, you wouldn't expect people are just going to be walking on top of the landscaping rocks. I mean, they're there for decorative purposes, not for a walkway.
They are, Your Honor. And so I think in this case is a bit unusual than the other ones I've had in front of you in other courts. It's pretty rare that you get a situation with a trespass that we argue. And normally you have an invitee situation.
Sure. Now, if he'd been there with Ms. Hayes, he wouldn't be a trespasser, right?
Well, that's still debatable because I think that having this individual come on for an investigative purpose, though not authorized by the county, I would have trouble agreeing with an argument that he was an invitee.
That's an interesting question to me, and I wonder, I'm thinking back to my days as a private practitioner, which might have been a few years ago. I remember going to various clients' premises when there were disputes about their property. As an attorney, yeah. I remember walking with clients on easement areas. And I guess I didn't believe that I was trespassing when I did so for my client to show me this is what's going on here so that I could finish my investigation for purposes of filing a claim. So if Ms. Hayes was there with her lawyer, would that be a trespass?
I think if she was there with the lawyer, they would need to give notice. Hey, I'm coming on the easement with the lawyer, or I'm coming out with a public official. If you as an attorney, Judge, had gone out to property to investigate with the client, I think you would have to give notice. And that's something I argued. You know, we didn't even get notice that they were doing this investigation. I think it's kind of outside of the realm of what we're dealing with today. But however, and first of all, Ms. Hayes, who has the easement, didn't even call him. So your hypothetical is interesting to me. It's an intellectual debate, but that didn't happen. She didn't even contact him, nor did the daughter. And so we're still trying to figure out why he was even out there. And so I have trouble with any type of investigation going on. But I think that would, at best, maybe because you wouldn't have the invite, it would maybe be a licensee issue as opposed to, but definitely not an invitee. But the burden is on the plaintiff in these cases to show he wasn't trespassing, and they've got nothing. We've taken a lot of depositions in this case, and no one has ever said he had permission, he could do this. And he also exceeded the scope of the easement, which is simply for ingress and egress, not for investigation purposes. And that's why I took care to speak to counsel for the county to say, hey, has this been authorized? And the response said, no, he was not. He was not in the scope of employment. And it was pointed out specifically in the letter that actually there would be no reason to be there. The site plan, the zoning, everything had been taken care of. There are no issues pending on this property. So an investigation.
There's no zoning issues present on the property. And are you aware of any provision of the zoning ordinance that would be implicated by a servient estate owner's interference with the dominant estate owner's easement rights in a private easement?
I am not, Your Honor.
Neither am I.
But I am not aware of any allegation that we have There's been no formal filing. There's been no lawsuit or.
Right, but even if there were, that's a matter of a private property suit.
It's
not
a
zoning.
private property situation, and in this situation, for some reason, he wanted to come out and look at it. I don't know why, but at his own peril. And so I think that there are no facts that support keeping this claim alive.
All right, thank you.
You're welcome.
Mr. Claxton, your response.
Might I remain seated, Your Honor?
Yes, that's fine.
Thank you, Judge. The first point, Judge, I bring it up because I'm surprised to hear defense counsel say it today, that there's no argument that the accident occurred in the public beach area. To the contrary, Judge, on page 7 of my response brief, I cited exactly where defendant has said that. And I only cited it the one time in their initial disclosures because I didn't expect it to be a contested issue. I believe they actually raised it as a defense. Furthermore, Judge, and Mr.
Right now, but I mean, I looked at all of that and there's lots of interesting stuff at the edges, but really you're saying this happened in the easement area.
My belief when we filed the suit was that the hole was in the easement area.
Yeah, and I think it was. I mean, there doesn't seem to be a genuine issue of material fact about that. And that's the, I mean, would you agree with that?
I would agree with you that that's the central thrust of an ordinary negligence claim. Yes, I think you've correctly identified.
So that would mean that that count 2 should probably be dismissed on a C8.
Other than the fact that when he's deposed, Mr. Heinz insists it certainly was on public beach. And Mr. Harris points out to him at the time of the deposition, are you sure this is the route you want to take? I mean, you think this helps you? Oh, for sure. It was on the public beach area. And Judge, if they want to create that issue of fact, I think let them lie in the bed, take it to a jury and let a jury decide that that's not true. Candidly, Judge, I would rather a jury see that exchange and test that truthfulness for themselves.
Okay, well, I mean, I'm not interested in leaving counts alive just for the jury to play around with. So I mean, I'm almost certainly granting C8 on count 2. I'm much more interested in count 1. Why is Mr. Studer not a trespasser on the Heinz's property?
A number of factors, Judge. First of all, again, responding to Mr. Deegan, he said there's no testimony that anyone invited him. That's just not true. Dawn and Diane, Ms. Petrius and Ms. Hayes both indicate they wanted him there. Dawn indicates, yes, I asked him to be there. Ms. Petrius further says, now I admit, Judge, this is a factual difference between the two depositions. Ms. Petrius says, yes, my mom knew I was asking him to be there. Ms. Hayes said, it's good that he was there. I would want him to be there. He was doing the right thing. Now, admittedly, Judge, she indicates that she did not call him. However, Judge, the testimony is that she set up a survey that morning, asked her daughter to march down there because she was in Florida and document the survey because she had a feeling those stakes would not remain.
Do you think that easement would allow Ms. Hayes to bring guests?
I do, Judge. And Judge, it's an interesting point that you raise for a couple of reasons. Defendant spent 2 pages of law trying to convince the court to narrowly construe the easement, and at least 3 different arguments that hinge on how they say the court should interpret the easement, but they've only pulled 2 sentences from the easement itself. If you actually read the easement, it's quite broad and the language is not good for defendants. The easement indicates it shall run with the land, it shall bind and benefit the owners and occupiers of the benefited parcels, which Dawn is. There's no serious dispute here that she is an owner.
Well, I'm not sure that's true. I think Mr. Deegan is in fact disputing that. And
Judge,
Dawn wouldn't have had any right to use that easement on her own accord without Diane's permission, would she?
Well, Judge, she does have a vested interest.
As a remainderman.
And Judge, the distinction being made by the deed itself is owners and occupiers of the benefited parcels, their transferees, successors, and assigns. Arguably, that covers Dawn 2 different ways.
Well, how? I mean, a successor only occurs when, or assigns when there's a succession or an assignment. This Ladybird deed was an enhanced life estate that Ms. Hayes had. And the case law is pretty clear that when there's a reserved life estate, the remainderman does not have a present possessory interest.
And I understand, Judge, but the easement itself doesn't say those with possessory interest. It says owners, transferees, successors, and assigns.
Okay, so was Ms. Petraeus an owner?
I believe she was, Judge.
She didn't own the fee. She's a remainderman.
She does not own it in fee simple.
Okay, she's not an owner. Is she a transferee?
I would argue, Judge, that she is not a transferee for the reasons that
Okay,
you
is she
pointed
an
out.
assignee?
I think she could be an assignee, sure.
How can someone be an assignee prior to an assignment?
The assignment, Judge,
never
you're
heard of such a
talking, I'm sorry.
I've never heard of such a thing.
I'm not talking about a deeded assignment, so to speak. Ms. Hayes says in her deposition very clearly, of course my daughter would have the right and the ability to use my property. She grew up here. This is her home.
Okay.
I do think that the language of the easement, Judge, that it shall bind and benefit the owners and occupiers of benefited parcels, militates that direction. Furthermore, Judge, this argument that the defendants are making that, well, even if they had a right to walk it, that doesn't mean they had a right to document or to photograph or to defend their legal right. That's not what the easement says. The easement on its face says, as long as their use, the defendant's use, does not damage or interfere with the grantee's use.
Well, it does say it's got to be for ingress and egress.
And Judge, a walking path, that's what it's been recognized as.
So let me ask you, even assuming that that Miss Patrius had a right to use that easement, which I'm not sure she did. And even assuming that ingress and egress encompasses walking down there to check it out and take some pictures. Why on God's green earth is Mr. Studer standing upon the landscape box? And why is that within the scope of an easement?
So Judge, the purpose of the easement, again on its face, is to provide a walking path to and from the beach.
Right, not to stand on the landscaping rocks. What's he doing up there?
He's documenting the obstruction of the path. That
You
is,
can't do that from the ground?
Judge, I think in hindsight, that's a fair argument. And I bet as he sits here today, Mr. Studer wishes he probably had not stepped on the rock. But that was the argument being made. And it's argued not just by Ms. Petraeus, by Ms. Hayes, by Mr. Rowe, by all of them, that this is the conduct, this is the obstruction being complained of.
Can I ask you, why is he out there at all? He's a zoning official. Even assuming that you're right about Ms. Kaufman's letter being wrong about that and the affidavits or testimony from commissioners about individual members of the planning commission going out and investigating zoning issues. This wasn't a zoning issue though, was it?
Judge, it's interesting you bring that up because this is not a question I don't think either of us had intended to ask Mr. Rowe, but it was a question he answered. This is not just like a hypothetical that it might be a zoning issue. Mr. Rowe said, yeah, that's what actually happened to me. I was building too close to the public easement and zoning came out. They didn't notify me in advance and they told me I was encroaching on that easement.
Yeah, that's some past thing. I'm talking about this complaint about that Miss Patrius or Miss Hayes even was having that the Hineses were interfering with their easement rights. I get cases like that all the time.
Sure.
I kind of wish I didn't, to be honest. Those cases are very contentious usually, and they take a lot of court time. But they're not zoning questions, right? A dispute between two private property owners about whether one of them is interfering with the easement rights of the other. That's not the county's business.
Certainly, Judge, I think you're right that it is a private interest and suit could be brought that way in a private case. But the argument is that there's a number of actions Mr. Hines is taking. He builds a concrete parking pad actually over the easement. This is an allegation. I'm sorry, Judge. I'm not suggesting this is fact. This is an allegation being made. He builds a concrete parking pad over the easement. He puts in trees. He puts in, I think there's some talk about a tank. There's a number of easement tangential issues, which again, Mr. Rose saying, not just hypothetically, this is what happened to me. I did build too close to the easement and they told me, no, you can't do that. In his case, it was a zoning issue. Furthermore, Judge, I would indicate that if as Mr.
Well, you're again eliding what you're making an illusion there, right?
I apologize, Judge. I don't know what that word means.
Well, look it up, Lee.
Understood.
The fact that Mr. Hines had a past zoning issue does not answer my question about whether this complaint about the easement interference was a zoning issue. And the fact that you won't answer that question, I think highlights my understanding that it's absolutely not a zoning issue.
Can I make two more brief points on that, Judge?
Absolutely.
As Mr. Studer and several other witnesses indicated during deposition, his role there is to investigate and document, not necessarily to take action.
Investigate and document what?
Right. He doesn't know until he goes.
So Mr. Studer is not like a deputized king of the county enter onto private property whenever he willy-nilly wants.
Absolutely.
What right did he have to be on that person's private property, whether to investigate anything at all?
As to the easement, Judge, it would be Ms. Hayes and Ms. Petrius asking him to be there.
Anything else I need to know to understand your position?
Yes, Judge, if I might briefly cover a few issues.
Yep.
Judge, one of the first C10 motions I ever argued, I was the filing insurance defense attorney. There's a judge not far from here that said something to the effect of, Mr. Kleigstead, you got 10 breaths to convince me there's no genuine issue of material fact. Every breath you take after 10 is your argument getting worse. If there's this much going on, then there probably is a genuine issue of material fact. The point nobody is discussing here, everybody seems to agree that Ms. Petrius wanted John there. Now, I understand defendant is saying, well, not Ms. Hayes. Again, I would say that's a contested issue of fact. Ms. Hayes says she did want him there, and Ms. Petrius says, my mom asked me to call him. A fact nobody is discussing is that John was never warned off of the property. There were no trespassing signs. Nobody asked him to leave. In fact, testimony.
Hang on. Does that mean he can go to my house tonight and walk around my backyard?
Of course not.
Of course not.
He admits that.
Right. So they don't have to warn you off.
Oh, I agree, Judge. But we're
Okay,
talking
so what
about
point
this.
are you trying to make?
We're talking again about an easement which has a clear dominating estate. They're the ones who want him there, not the subservient estate. They don't ask him to leave, Judge. They ask him for his car.
All right, follow your own advice about the press.
Understood, Judge.
Can I briefly respond?
Hang on. No. He's not done. He's not done. I'm sorry. You'll get rebuttal argument.
Judge, I do think that Reitz v. Tippett is a very important decision where the officer knew darn well that the premises were closed, that people were not welcome. The Court of Appeals in that case, Judge, was not deciding between trespasser and invitee, or trespasser or licensee, because there's an ocean of difference between those three things. The Court of Appeals was saying, is he an invitee or a licensee? And the analysis is, if his presence there is only loosely connected with his job duties, then he's a licensee. That's what they decided he was. If he's more like a garbage man, more like a meter reader, if his presence there is closely connected with his job duties, we're going to graduate him to invitee. That's the distinction the Court of Appeals is turning on. I think that's applicable here, Judge. All this is to say, Judge, that if this honorable court decided there was a genuine issue of material fact as to how closely John's presence there was related to his duties, or if this court felt that his presence there is only loosely related to his duties. It's not really a zoning issue, right? It's only loosely related to his function as a public servant. If that's the case, Judge, then the decision tree is between licensee and invitee.
What if it's not at all related to his duties as a zoning official?
We never felt that the case turned on that fact, Judge. And in fact, we were a little bit surprised that this has become the World War III issue. Maybe that's naivety on my part. We didn't necessarily see that coming, that defendants would say, no, he's gone rogue. This is not within the performance of his duties. Nevertheless, Judge, I would still point back to the fact that he's called there by the interested party, by the holders of the easement.
All right. Thank you. Anything else I need to know to understand?
Judge, I can tell the court is frustrated and
hey, listen, I asked Mr. Deegan some tough questions. This is just what I do. I ask both sides tough questions because that's the only way I know when your argument breaks down.
Absolutely, Judge.
So no, I'm not frustrated with you at all. Go ahead and make.
Oh, no, I didn't think so, Judge. I guess one point on the notice.
You said so, so I thought you thought so.
I thought that the court was frustrated with the argument being made, not with counsel.
No, I'm not.
Judge, to the extent that they want to argue no notice, as you pointed out to Mr. Deegan in one of your tough questions, their argument proves too much. According to them, plaintiff can't miss the hazard. Well, if that's true, if plaintiff can't miss the hazard, then what do you mean you had no notice of it? You put it in. And Judge, that was a point that you made. But if we're construing facts in a light most favorable to the plaintiff, Ms. Petraeus says Mr. Heinz wasn't just aware that he placed these giant uneven boulders in the Hayes designated walking path, that he meant to do it, that it was his intention to render the walking path. That's what she says, Judge. In a light most favorable to the plaintiff, I think that helps us a lot. Judge, maybe just two more quick points. The argument being made here by defendants is the losing side of Smalley, right? What Mr. Deegan said was, well, if there was testimony that there was some ice in an alley and then a thing happened. Well, Judge, that is what happened. The testimony is that the landscaping boulders are straddling the line between the easement and the public beach. And only in stepping over that easement or stepping off that hazard does injury occur. That's Smalley exactly, Judge. What the defendants in Smalley are arguing is this is pure speculation. We don't know what caused this. Was it black ice? Was it this? Was it that? And the court says no. In the light most favorable to the plaintiff, there are a lot of related but-for causes here, right? It could be that it concealed the curb. Could be that they had to step over the hazard and that's what caused the fall. Could be that there's black ice from the melt-off. That is the case here, Judge. As you pointed out to Mr. Deegan, we've got three eyewitnesses, all of whom are saying, no, this is the spot and it's caused by this treacherous walking path, right? The idea that Ms. Hayes never had an issue, Judge, she actually testified she wanted to put up signs. Walker beware, because you can't see the soft ground under this grass. Again, taking a light most favorable to the plaintiff, I think that is a genuine issue. Last point, Judge, and I'll hush. To the extent that defendants are trying to convince this honorable court to strictly construe the easement, say, Judge, this needs to be narrowly read, they're essentially asking this court to do the opposite of the C10 analysis. The C10 analysis says take the fact in the light most favorable to the plaintiff, giving the plaintiff the benefit of any reasonable doubt. That's not what they're asking you to do, Judge. They're asking you to hold us to the clean lines of that easement. That's just not consistent with the C10 analysis. Thank you, Judge.
All right, thank you, Revato.
Yes, Your Honor, briefly, point I want to make one clarification. I do not represent an insurance company in this matter. I represent the defendant. It was noted that insurance defense, and I think that's inappropriate. But here we are on a C10 motion. We've already talked about C8 as the count two. And this motion has been pending. We've taken a lot of depositions. We have no issue of fact. The issues here as to the easement, there is no misinterpretation or other way to read that. The grantee shall use the easement only for the purpose of ingress and egress from the road to the beach, including such maintenance as the grantee deems necessary and appropriate. That's very clear language. And there is nothing in this easement that would provide for a rogue investigation by somebody who's been clearly not authorized to do this within the scope of his employment. So the claim fails. When they talk about, I guess I'm a little confused because they keep going that there's an issue of fact of whether it was on the public area, but there is no testimony that it was, and I think they conceded that it wasn't. But there's even, if there was an issue of fact of whether the accident happened on a public area, there's still no evidence that we caused some problem that caused an injury. And as to the testimony, because I want to be real clear here, as to whether or not, they keep saying, I heard exactly this from plaintiff's counsel. She agreed she wanted him there. Their testimony is very specific. This is Mrs. Bodner. She said, I had said that we had an issue. He was interested in coming out, but she didn't contact him. He contacted her. It is undisputed that plaintiff never sought any invitation from my client at all. There was no notice. And if this case goes forward, I guess people then can come around on an easement or private property and have a look around and do some kind of investigation. I'm still not clear what the investigation was for, because those rocks were put there for erosion control, and there's no issue as to whether or not that violated the easement. So I asked that the case be dismissed, Your Honor.
All right, thank you.
Thank you.
Defendants filed a motion for summary disposition of this injury action. There's count one, premises liability, count two, negligence. The injury in this case happened when the plaintiff stepped off a landscaping rock on property owned by the defendants and within an easement area, and suffered an injury. And I don't think there's any genuine issue of material fact that the injury happened in the easement area, and that's what was pled. And given that, the count two clearly, the negligence count clearly does in fact sound in premises liability. So the negligence claim count two does not state a claim upon which relief can be granted. So I'm going to grant the defendant's motion for summary disposition of count two, the negligence count under MCR 2.116 C8. Of course, the main issue is count one, the premises liability. And one of the issues, I guess a threshold issue, is what was the duty owed, and was plaintiff a trespasser? Here, there are some facts that are clear, both factually and legally, that the plaintiff did not have permission from the property owner to be present on those premises. That owner would be Marvin and Carrie Hines. They're the fee owner of the property. He did not have their permission to be upon their property. Diane Hayes did have an easement to access a portion of that property for ingress and egress to a beach area. And it's also clear that Mr. Studer did not have, before the fact, permission from Ms. Hayes to be there. The fact that after the fact she said, you know, she didn't have a problem with that is not the same thing as permission to be there. Also, Dawn Patrius did not, as a matter of fact in law, have a present possessory interest. Legally, she was a remainder man under a Ladybird deed, which reserved a life estate to Ms. Hayes. In fact, the Ladybird deed, it's an enhanced life estate with power to convey. And the black letter law is clear that the remainder men do not have a present possessory interest. So Ms. Patrius did not own the property that Mr. Studer was on, and she didn't have a right to use the easement on her own accord. And even if she's considered to be a guest of Diane as the easement holder, she certainly did not have any authority to bring her own guests. So even if I read the easement to say you can bring a guest for ingress and egress, which I think would be a fairly common way to read an ingress egress easement, that means that Ms. Hayes could bring a guest. It doesn't mean the guest can bring a guest. Otherwise, an easement is not really limited. It's open to the public. So the plaintiff did not have any permission from anybody that had authority to be there. Plaintiff's use of the easement did exceed the terms of that easement. He was not there for ingress and egress. He was there to document some alleged violation. And I'm still not sure what exactly he's doing standing on the rocks. Certainly, standing on the landscaping rocks is not ingress and egress. And the court is still left with the question, why was the plaintiff investigating anything at all? It was none of his business. It was none of the county's business. The county attorney gave a letter opining that plaintiff did not have county authorization to be on the defendant's property. The plaintiff disputes this and has some testimony from one of the county commissioners saying that, you know, he disagrees with the county attorney's letter. But plaintiff has not shown that there was any pending application regarding these premises that was pending in front of the Planning Commission. There was nothing pending with the Planning Commission about this property. So therefore, it did not warrant any member of the Planning Commission to enter the property to evaluate some application. Rather, the dispute here was a private one about easement rights. And as I said, we get lots of lawsuits about that. It wasn't a matter of public access. It wasn't a zoning violation. Plaintiff has failed to point out a single provision of the zoning ordinance that the Hineses would have been violating by their alleged easement issues that Mr. Studer would have even been there investigating. I mean, we're a servient estate holder, that'd be the Hineses, where they are interfering, even assuming that they were interfering with Ms. Hayes' dominant estate holder's rights under a private easement. That's not a question for zoning. That's not a question for the county to decide. That's a question for a court of law to decide. Under plaintiff's theory, a citizen having a private land dispute with his neighbor can just have the government enter the neighbor's property without permission to document that. And that is most definitely not the law, and it doesn't give proper respect to private property rights. So on these facts and but under the law, I agree with the defendant. There's no genuine issue of material fact here. The plaintiff was in fact a trespasser on property owned by the Hineses. As such, defendant owed only a duty to refrain from willful and wanton misconduct. Plaintiff has failed to present any such evidence. Accordingly, plaintiff's motion for summary disposition count 1 is granted under MCR 2.116C10, Count 2, as I said, is dismissed under C8. And Mr. Deegan, you can submit an order to that effect.
Thank you, Your Honor, I will.
All right, thank you, counsel.
Judge, one brief question. To the extent that 2116 indicates that a party who is, loses, if you provide for that, under a 2116 motion, may seek leave to amend their complaint. Might we have an opportunity to do that, Judge?
What's your amendment?
The only thing I can think of as I sit here, Judge, would be the willful and wanton nature or lack thereof.
You were on notice of that. I mean, no, and that would be so futile. There's no evidence on this record whatsoever of willful and wanton misconduct.
Thank you, Your Honor.
No, and that's really not something to bring up like after a ruling, just sort of on the fly, and I'll think of something. That's not how that works either.
Thank you, Judge.
Thank you. All right. All right, and this brings us to Schoon v. Martin, file 25-9171CH. I've got some folks here. Just admit.
I think you have one person, I think.
I think I've got a Michael Martin. I've got Teresa Smith. And they've got, let me just double check here. All right, Betty, can you tell me again your last name? I forgot. We've been pretty busy here this morning.
Musser, M-U-S-S-E-R.
Okay, and
I should have identified myself there. I'm
okay,
sorry.
no, you're good. You're good. All right, let me put you back. We're almost to your case. I'm sorry.
Who's a Musser?
No, get rid of yours, dude.
All right. And all right, I see Mr. Martin, Miss Smith. There's a James S24 Ultra.
Musser,
Who are you? All
There's
right, I'm gonna mute them because they're talking. All right, so it looks like we've got plaintiff, are you Miss Schoon? We've got plaintiff, Miss Schoon present. Some of the other plaintiffs are present by Zoom. And Mr. Rotter, you're here for the plaintiff, and this is your motion. There's a default that's been entered against the defendant. This is your motion for entry of default judgment. Go ahead.
That's correct, Your Honor.
Okay.
Can I approach the bench for a second?
Yes. Seconds.
Yeah.
Defaulted, and in fact refused to participate in the action. It's a partition action, so I think we do need some brief testimony about whether the premises are suitable for physical partition, and if not, what the value of the property is and the defendant's interest in the matter. So, Mr. Rotter, I would allow your client to testify either from where she's seated next to you or from the witness stand. Do you have a preference?
Where would you feel more comfortable, here or up there?
I'm good either way. I'm
Okay.
gonna be nervous in either seat.
All right, well, we'll make you less nervous. We'll just let you sit there. Could you stand and raise your right hand for me?
Yes,
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can have a seat. And is your name Catherine Schoon?
It is.
Okay, Mr. Rotter, go ahead.
Ms. Schoon, how do you spell your last name? I'm sorry, spell the whole thing.
Catherine, Kathryn. Schoon, S-C-O-O-N.
And you and your siblings own some real estate in Sheboygan County that a deed was attached to the complaint, is that correct?
Yes.
And the deed is also attached to the proposed order describing the real estate. Let me just show that to you. The property involved is identified as.
You want me to?
If you can read that, yeah.
lots 54 and 55 in Crease Landing subdivision, section 14, township 38 north, range 2 west.
And that's located in Sheboygan County, Michigan?
Correct.
And you own that with your siblings?
That is correct.
Now, when the deed was created, there were how many siblings?
6.
6, and now one was passed?
Correct.
And which one would that be?
That's Jacqueline Willard.
Okay, and then Mr. Martin, Thomas Martin, excuse me, his relationship to you is as a sibling?
He is my oldest brother.
And he owns what percentage then of that?
Would be 1/5.
20%.
20%.
Yeah.
Mhm.
The lots 54 and 55, is that in a residential area?
It's at the end of a road. It's kind of a subdivision of sorts. It's a road in U shape.
And this is a residential building that's on one of the lots or straddles the
It's a
lot line?
house. Mhm.
It's a house.
It's a house.
So it's not acreage that can be divided into so many 5 units of equal value, is that correct?
Correct, yes.
Okay, so it has to be sold somehow
Correct.
in order to make this work. Okay. You caused an appraisal to be made of the premises, is that correct?
We did.
And who performed the appraisal, do you know?
This one was Richard Danish and
Oh, that's
he's from
fine, Richard Danish.
Sunrise, I think,
So
Sunrise.
he's a certified appraiser.
He is.
He represents himself to be, at least on the paperwork, is that correct?
Yes. Mhm.
Okay, and what does he value the property, or what did he value the property at, and what date was that?
This was just this past February, and this is the second appraisal we've had, and we wanted it most update. February 14th of this year, $243,000.
Yeah, what you're asking the court to do today is enter a judgment, essentially compromising your brother's position and allowing you and your siblings to purchase that. Is that correct?
That's correct.
That's all I have, Your Honor.
All right, thank you. And what relief are you asking? Well, let's see, did you submit a proposed?
I did.
Okay.
I didn't have it in my file, but I've got a copy that I had given my client.
Okay, and the relief is consistent with that sought in the complaint. And you're asking, the relief you're asking for is for the court to determine the value of the real estate, that it's incapable of being physically partitioned, that the defendant's interest at 20% is $48,600, and that upon payment from the plaintiffs to him could be recorded to effectuate that. I think all of those findings are well supported by your pleadings in the testimony today. And I would make those findings. My one question, Mr. Rotter, is that this property being held as joint tenants with rights of survivorship, I'm of the impression, and in fact, I had a case earlier today where I was talking about this, that under Albro v. Allen, under Michigan law, that's a joint life estate with indestructible contingent remainders. So I'm not sure whether by this action I can extinguish, I can partition his interest in the life estate and have your clients purchase his life estate. And maybe that's a good bet that he won't outlive all of them. But if he did, do I have any legal authority to extinguish his remainder interest?
I believe you do, Your Honor, and I would be happy to supply a brief on that.
Okay, so I will, I'll reserve on the question about whether the judgment would include his interest in the fee or only his interest in the life estate, and allow you 21 days to file a brief on the question. And upon that, if I have need for any questions or clarification, I'll set it for further hearing. Otherwise, I'll just enter a judgment. But in all other respects, I'll grant your relief requested. I just won't sign the order today.
Okay, thank you, Your Honor. I've got some physical things coming up here.
Okay.
I have 28 days.
Absolutely. Excellent.
I know that last week we were made aware that Tom had sent a letter into the court in December in response to the complaint that was served. And it seems a little bit vague in reference to the home itself, but I do have a letter that he has given us. I know it's from the past, but it is real specific on the fact that he wants to relinquish all rights to the home. If that makes a difference or helps in any way to show.
It wouldn't. He's been defaulted on the question, but I just have to have Mr. Rotter help me see a legal question from his point of view. So I'm going to give him 28 days to file a brief about that. Otherwise, the matter is taken under advisement.
Okay, thank you.
All right, thank you, Mr. Rotter. All right.
Yes.
All right, we're gonna move into the family division. No, wait, no, actually, I'm gonna call something out of order, so we can wrap up the civil division cases. And I'm gonna call Garcia v. Mariana Enterprises.
Morning, Your Honor. Steve Garcia.
Great.
Morning, Your Honor. Being on behalf of the defendant.
Good morning. And this is, Mr. Martin, your motion to strike the jury demand. I see you've also got some other motions up, but those are noticed for into July. So the only thing up for today is the jury demand question. Is that right?
That's correct.
Okay, so I've reviewed your motion, the response, and the reply. Go ahead with any argument.
I have nothing further to add to the motion, Your Honor.
Okay, thank you. Mr. Garcia, your position, sir?
Your Honor, I have not seen the reply. I did not receive a copy of it, but there's not much else to say on this. Whatever you decide is perfectly fine.
Okay. In this case, the plaintiff representing himself, he is an attorney, but he's not licensed in the state of Michigan. He's representing himself. As such, he's required to adhere to the Michigan court rules. He filed a complaint and he asked for a jury. He filed a jury demand, but not as a separate pleading and didn't pay the jury fee. And that was in violation of the court rules. The court rules do provide that a party that fails to follow that waives trial by jury. And the defendant, I'm sorry, the defendant wishes to hold him to that obligation. And even to the extent that the court is, courts are oftentimes motivated. There's a great disagreement about whether that's rightly or wrongly to give some grace to self-represented folks. That grace has much more limit when the person representing themselves is a sophisticated self-represented litigant who's in fact a licensed attorney in another state. And so Mr. Garcia is going to be held to the court rules. I grant the motion to strike the jury demand. Mr. Martin, you can present an order.
Counsel.
Agree as to form, Mr.
Perfectly fine, Your Honor.
Okay. All right, so I'm going to go ahead and sign this. Do you want me to just give it to the clerk or do you want me to give it to you for filing, Mr. Martin?
Just give it to the clerk.
Okay, all right, so I'll just tender it to the clerk in the courtroom and we'll see you guys back in January.
Thank you.
Or I'm sorry, July.
Thank you.
All right, now we're going to move back into the family division, so let me end the live stream.
So I'm going to go ahead and call this one for today, ladies and gentlemen. For now, ta-ta and ciao-ciao. I will catch you on the next one. You all have a wonderful, wonderful evening.
Come down to it all with your tools in hand, making magic flow. Every broken part, you help me grow. my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your hour, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's